Good morning. The Judiciary Committee will come to order. And without objection, the chair is authorized to declare recesses of the committee at any time. We welcome everyone to this morning's hearing on examining anti-Semitism on college campuses. Before I give my opening statement, and before Mr. Connors gives his, I'm going to yield to him so he can say a word about the tragedy that occurred in Texas over the weekend. The gentleman is recognized.
Top of the morning, and I thank you, Mr. Chairman. Welcome all 9 witnesses, all-time hearing, and the distinguished gentleman from Wisconsin, Mr. Sensenbrenner. Let me just say briefly that before discussing the important topic of today's hearing, I want to raise another issue that we must unfortunately confront with urgency. On Sunday, a gunman shot and killed 26 churchgoers in Sutherland Springs, Texas. We now know that information concerning his court-martial for domestic abuse should have been submitted by the Air Force to the National Instant Criminal Background Check System. He should have been prevented from purchasing firearms from licensed gun dealers via the Brady background check system. Yesterday, before this information came to light, I wrote to you, Mr. Chairman, requesting that the briefing planned for our members tomorrow afternoon by ATF on the issue of bump stocks be expanded to include the FBI to discuss the background check issues related to Sutherland Springs, and that the briefing be conducted as a formal hearing open to the public. Now that we have even more information that there's been a breakdown in the implementation of our background check system, I ask respectfully that we include relevant officials from the Department of Defense and the Air Force. And I believe, as I think you do too, that we should proceed quickly to learn what happened, and the public deserves to hear answers directly. Therefore, sir, I renew my request and expand it concerning tomorrow's briefing, and I thank you for this opportunity.
If the gentleman would yield.
With pleasure.
I thank the gentleman for his comments, and I share his concern about having an effective NICS system and that data about domestic violence go into that system, including data that may be developed as a part of our military tribunal system. Therefore, we will look into a briefing on that subject. Whether it can be accommodated quickly enough to be done tomorrow or not, we'll have to see. But my plan is to proceed with the briefing by the ATF. If we can't incorporate the other into that briefing, we will do it at another time, and we'll certainly take under advisement your request that there be a public hearing. I think it's important that we get as much information and be as informed as possible, and that's where we stand right now.
I thank you for your interest. Yes, sir.
I thank the gentleman from Michigan for yielding. I was the one who was insistent on putting the instant check system in the Brady bill, which was passed and signed by President Clinton in 1993. And at the time the legislation was drafted, I made the point that the National Instant Check System would only be as good as the data that was put into it. And it took about 5 years to appropriately automate and input records, not only for felony and convictions, mental incompetency adjudications, as well as domestic violence legal action. And you know, we found that one state kept all of these records in boxes of 3x5 cards located in every county courthouse. That took a while to, finally automate. that. So, I don't think we can blame the law for the failure of the transaction of the shooter to be identified and the sale being denied. I don't think we can blame the system which we set up almost 25 years ago, because the system has worked in hundreds of thousands of cases. I think we have to blame the Air Force for not doing what was necessary to let the system be able to identify this gentleman when he came and purchased the firearms that he ended up using in a truly horrific killing, particularly as people were in church trying to, express their freedom of religion and worship God in by their own consciences. So, I think we have to identify, why this failure was. And it's not just the Air Force. It could be any clerk of court anywhere in the country that could have done that. And I think this has got to be a lesson that when you've got something that is disqualifying, that has been adjudicated by a court, get it into the system and get it into the system right away. And I thank the gentleman for yielding.
I thank you both.
I thank the gentleman, and I thank both Mr. Conyers and Mr. Sensenbrenner for their observations. I want to return to focus on the important matter that's before us today, but we will proceed with the briefing tomorrow, and we will add additional information or a separate briefing depending on what time allows.
Thank you.
I now recognize myself for the purposes of an opening statement. Racism, sexism, and anti-Semitism, among other forms of animus, are abhorrent whenever they appear, including on America's college campuses. While our federal civil rights laws have long addressed discrimination based on race, sex, and ethnicity, a debate is ongoing whether anti-Semitism on college campuses warrants a unique response compared to how harassment based on race or sex, for example, is addressed. This hearing will examine that question, among others. There is widespread bipartisan condemnation of anti-Semitism, which I have said is abhorrent and does not reflect core American values of equality and religious freedom. I'm also concerned about the so-called BDS movement, an effort that, through boycott, divestment, and sanctions, seeks to end international support for Israel. It took just 11 minutes for the United States to recognize Israel after it formally declared independence in 1948. And ever since then, the United States and Israel have had a strong relationship based on shared democratic values and common security interests. I will do everything I can to ensure that relationship remains strong. There are those who disagree in various ways, of course, including student, faculty, and administrators on college campuses. I will also do everything I can to ensure their right to speak is protected under both the First Amendment to the United States Constitution and free speech principles generally. It's in that spirit of welcoming all perspectives that I've convened this hearing today. When do speakers, scholarship, or student protesters that are harshly critical of Israel constitute anti-Semitism? What is the nature of anti-Semitism on college campuses today? Has the Department of Education in the past or today adequately examined allegations of anti-Semitism on college campuses? How does existing law address harassment based on anti-Semitism? What impact would some other approaches have on freedom of speech, student relations, and academic freedom? And what precedents would they set, good or bad? Those are just some of the questions I look forward to discussing with today's witnesses. It's now my pleasure to recognize the ranking member of the Judiciary Committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Mr. Chairman. I welcome the witnesses, and I wanted to mention that today's hearing on examining anti-Semitism on college campuses is a part of a continuing discussion that our Judiciary Committee has had on the confluence of our twin interests: protecting equality of opportunity and freedom of speech in institutions of higher education. Our particular focus today is on anti-Semitism, one of the most ancient forms of prejudice that unfortunately not only continues to exist, but in some places has even seen resurgence in recent years. As we hear from our distinguished panel of witnesses, I'd like for us to keep several points in mind for context. To begin with, anti-Semitism on college and university campuses, like other forms of invidious discrimination against students, remains a very real concern. According to the Anti-Defamation League, as of September 30th, anti-Semitic incidents increased by 67% in 2017 compared to the same period last year. And there was a significant surge in these incidents after white supremacists marched in Charlottesville, Virginia last August, during which some of those marchers shouted, quote, "Jews will not replace us," end quotation. Additionally, the League reported a disturbingly high number of anti-Semitic bullying and vandalism incidents in K-12 schools and college campuses across the United States. In recent years, other reported incidents included the vandalism of campus property with swastikas and the passing out or posting of leaflets with white supremacist and anti-Semitic content on campuses. In light of the foregoing, I wholeheartedly support the Department of Education's 2010 guidance interpreting Title VI of the Civil Rights Act of 1964 so as to protect Jewish students and other religious minorities from discrimination. This guidance rightly clarified that while Title VI, which prohibits discrimination on the basis of race, color, or national origin in programs that receive federal funding, does not include religion as a protected characteristic, it does prohibit discrimination against members of religious minorities if it is based on an actual or perceived shared ancestry or ethnicity. Although this guidance dates from the Obama administration, the Trump administration so far seems inclined not to change this interpretation, and I would encourage the current administration to continue to keep it in effect. Finally, while we must ensure a campus learning environment free from discrimination, we must also be careful not to stifle legitimate, if hard-edged and even offensive, political debate on controversial topics. The vigilant protection of the right to free speech is a fundamental hallmark of a democracy and of academic freedom. Indeed, other than in the context of speech that amounts to objectively severe or pervasive harassment, and in a few other limited circumstances, the remedy for bad speech is more speech. Equality and free speech are not and must not be pitted against each other as if they were opposing values. Both values are central to our democracy and to ensuring a free society. And in closing, I thank the chairman for holding this important hearing, and I look forward to the testimony of our esteemed witnesses. Thank you.
Thank you, Mr. Conyers. We welcome our distinguished witnesses, and if you all would please rise, I'll begin by swearing all of you in. If you would please raise your right hand. Do you solemnly swear that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. Let the record show that the witnesses answered in the affirmative, and please be seated. This is a wonderfully distinguished panel. All of you have excellent professional and academic credentials. You might not be surprised to learn that because there are 9 of you, I'm not going to give all of those details about each of you. So these introductions are on the brief side, but they're nonetheless important. Our first witness is Rabbi Andrew Baker, Director of International Jewish Affairs at the American Jewish Committee. Our second witness is Pamela Nadell, Director of Jewish Studies Program at American University. Our third witness is Rabbi Abraham Cooper, the Associate Dean and Director of the Global Social Action Agenda of the Simon Wiesenthal Center. Our fourth witness is Barry Trachtenberg, the Michael R. and Deborah K. Rubin Presidential Chair of Jewish History at Wake Forest University. Our fifth witness is Paul Clement, a partner at Kirkland & Ellis, LLP. Our sixth witness is Sandra Hagee Parker, Chairwoman of the Christians United for Israel Action Fund. Our seventh witness is Jonathan Greenblatt, the CEO and National Director of the Anti-Defamation League. Our eighth witness is Suzanne Nossel, the Executive Director of PEN America. And our ninth witness is Ken Stern, the Executive Director of the Justice and Karen Rosenberg Foundation. Welcome to all of you. Your written statements will be entered into the record in their entirety, and we ask that you summarize your testimony in 5 minutes. To help you stay within that time, there's a timing light on your table. When the light switches from green to yellow, you have 1 minute to conclude your testimony. When the light turns red, that's it. Time is up, and it signals your 5 minutes have expired. Rabbi Baker, welcome. You can begin.
Thank you, Mr. Chairman, Ranking Member Conyers. In my work at AJC and at the OSCE, I have focused on Europe and the problem of anti-Semitism there. While the number of incidents and their severity are much greater than here in America, there are important parallels that have bearing on addressing anti-Semitism in this country, and in particular with the situation on our college campuses. This has much to do with the essential first step of understanding the nature of anti-Semitism and the importance of defining it. 15 years ago, we saw a surge in incidents. We also saw a new form of anti-Semitism, whereby the state of Israel was demonized, where its basic existence was being challenged. This affected the lives of European Jews themselves. They were frequently conflated with Israel and subject to verbal and physical attacks as a result. Merely giving voice to their own pro-Israel views could subject them to social intimidation and personal harassment. In 2004, the European Monitoring Center, the EUMC, conducted its own survey on anti-Semitism, collecting and evaluating data and conducting personal interviews with Jewish leaders. At the time, few countries bothered to identify hate crimes, let alone specify those that were anti-Semitic. A majority of the EUMC's own monitors did not even have a definition of anti-Semitism to guide them. Meanwhile, the personal interviews in the study revealed a level of anxiety and uncertainty that had not been seen in decades. The EUMC acknowledged the need for a clear, comprehensive, and uniform definition to strengthen the work of its monitors, help governments in understanding and responding to the problem, and to make sense of the pessimistic predictions of the Jewish leaders surveyed. In the fall of 2004, the EUMC director invited me to present her with a definition of anti-Semitism. We began with the contributions of academic experts in the field. They were shared with other scholars and practitioners around the world until a final draft document achieved consensus. It was my responsibility to negotiate agreement on a final version with the EUMC. And so in March 2005, it issued what has come to be known as the Working Definition of Anti-Semitism, a core paragraph with examples. And let us also be clear, the purpose of this definition and of the EUMC itself was not just to assist monitors in filing reports, it was to make a difference in the day-to-day safety and security of Jews and of all Europeans, to increase understanding, to raise awareness, yes, to be used by civil society and government monitors, but also by law enforcement, by justice officials and educators. References to anti-Semitism with regard to the state of Israel were both the most important and the most controversial in this definition. Anti-Israel animus was behind many of the physical attacks on Jewish targets, even as government authorities frequently dismissed them as political acts. The extreme verbal attacks had their own corrosive impact on Jewish community security. The examples were designed to bring clarity to this new form of anti-Semitism. For those who feared it could inhibit critical debate, the definition also stated one should take into account the overall context, and also that criticism of Israel, similar to that leveled against other countries, cannot be regarded as anti-Semitic. Over a decade has passed since this definition was issued, and we can see why using it has become valuable. Demonstrations in some European cities started as anti-Israel and became anti-Semitic. Police need to be prepared for this. So the definition is part of police cadet training in the UK, and it's now included in a newly published OSCE guideline on Jewish community security. An arson attack in a synagogue in Germany was determined not to be anti-Semitic because of the political views and religious affiliation of the attacker. In Austria, a call to kill Jews was deemed not anti-Semitic for the same reason. Thus, the Austrian and German ministers of justice include the definition in training police and prosecutors and judges. In May 2016, IHRA, the International Holocaust Remembrance Alliance, adopted the definition. It has since been adopted by the governments of the UK, Romania, Austria, Germany, and Bulgaria. Earlier this year, it was recommended for use by the European Parliament and the OSCE Parliamentary Assembly. The US government has its own record of use. The Global Anti-Semitism Review Act of 2004 called on the State Department to appoint a special envoy and stated that anti-Semitism has at times taken the form of vilification of Zionism, the Jewish national movement, and incitement against Israel. It called on state to report on acts of anti-Semitism around the world. In that report and a subsequent one, the working definition was employed. I am an advocate for using it. If we're to be successful in combating anti-Semitism, we must first understand it. We must define it. Some said it would be used to stifle criticism of Israel, but there's ample evidence in Europe that public criticism of Israel is even more vocal than a decade ago. But there is also a recognition of the very real problem of anti-Semitism as it relates to Israel and the dangers it poses to the Jewish community. This ought to be instructive when addressing anti-Semitism as it appears on college campuses. Finally, in the OSCE, I'm often joined by colleagues whose mandates cover other forms of intolerance against Muslims, Roma, Christians. Some people said adopting a definition of anti-Semitism would lead to demands for other definitions, but that has not happened. Those problems are no less serious than anti-Semitism, and the need for governments to address them is every bit as critical.
Rabbi Baker, your time has
Thank you.
expired. If you could sum up in a sentence.
My last sentence, even though the representatives of vulnerable groups are not saying they need a definition, unlike anti-Semitism, those other forms of prejudice are easy to recognize, if sadder still, that they are so prevalent. Thank you.
Dr. Nadel, am I pronouncing that correctly? Thank you. Welcome.
Thank you. Got it. Thank you. Thank you, Mr. Chairman, Ranking Member, and distinguished members of this committee for inviting me today. As a scholar of American Jewish history and also as president of the Association for Jewish Studies, the Learned Society for scholars in my field, I know that our country's encounters with anti-Semitism began in 1654 when 23 Jews landed in New Amsterdam and its governor tried to expel what he called this deceitful race of hateful enemies and blasphemers. Had he succeeded, perhaps we would not be here this morning. But he failed, and since then, Jewish immigrants have come to America from around the world and called our nation home. As citizens, American Jews enjoy the same right to freedom of speech that allows others to voice their contempt for the Jewish people and the Jewish religion. Anti-Semitism, a malevolent ideology, has waxed and waned across the landscape of American history. The political moment, economic dislocations, social forces, the movies in their heyday, and social media in ours set its volume control. We are, by all accounts, sadly, at one of those moments where the volume on anti-Semitism in American life is turned way up. When violent protesters chant, "Jews will not replace us," American Jews are rightly fearful. The hard evidence about the rising numbers of anti-Semitic incidents is indisputable, but today's hearing is about the climate of anti-Semitism on campus, and it was triggered by those who have pointed to our colleges and universities as, quote, hot spots of anti-Semitism and anti-Israel bias. Are campuses really hotbeds of anti-Semitism, or are they places where Jews, one minority among many, meet from time to time stupidity, insensitivity, and prejudice? Is anti-Semitism so pervasive on the campus that it has created a hostile climate for Jews? Social scientists find that when Jewish students are handed a list of anti-Semitic statements, nearly 3/4 confess that they were exposed to at least one of those statements in the past year. But the same students do not characterize their campuses as anti-Semitic. Instead, they report that they feel safe there. When they do experience discomfort as Jews, they trace it to the stridency of both sides of the Israel-Palestine debate. While that debate can devolve into anti-Semitism, such political speech is not ipso facto anti-Semitic. Students say that anti-Semitic expression comes mostly from their peers, not from their professors or the administration. One study even recognizes that we have, quote, more noise than accurate information about what is really happening on campus around anti-Semitism. The students surveyed are smart. They recognize that anti-Semitism is a significant problem in American society, but they don't characterize their campuses as anti-Semitic. Their research confirms my own impressions and also what I hear from my Association for Jewish Studies colleagues teaching around the country. Unquestionably, there are explosive incidents. Death to Israel and to all Jews posted on a Jewish student organization's Facebook page. But deplorable incidents do not prove that the campus is rife with anti-Semitism. You may have heard that recently on my own campus, Confederate flags affixed with cotton stems were posted on bulletin boards just as we were launching our new Anti-Racist Research and Policy Center. But you may not know that many of those flags were affixed to the bulletin board of the Center for Israel Studies. When such revolting racist incidents occur, the response from the university leaders is forceful and swift. We hold town halls. We issue statements of condemnation. We offer students counseling and opportunities for healing. We launch investigations. Perhaps there are campuses where administrators respond diffidently to such events, but I believe them to be the exception. Are anti-Semites targeting the college campus? Unfortunately, yes. Do Jewish students encounter anti-Semitism there? Sadly, yes. Is anti-Semitism at the epicenter of campus intolerance, as one report claims? Has it created a climate of fear that impinges upon Jewish students' ability to learn and experience college life to the fullest? My impression, buttressed by social science research and my Jewish studies colleagues, an unequivocal no. Thank you.
Thank you. Rabbi Cooper, welcome.
Thank you, Mr. Chairman, Mr. Conyers. Good to see you, distinguished members. In the past several years, Jewish students on certain college campuses, not all, but a large number, have been subjected to unprecedented levels of anti-Jewish sentiment, leading many to feel uncomfortable participating in Jewish campus life or other campus activities whose participants are especially hostile to Jewish students. Jewish students often can't table their organizations at student event fairs without being physically surrounded and shouted down by extremist anti-Semitic campus organizations. They can't bring speakers to school like every other student group and gender and racial and ethnic group can, because the speakers have and will be heckled into silence. They're often reluctant to run for student government at some schools because they've seen the numerous times in just the past few years that Jewish students have been called out because they are Jews and often excluded from student government expressly due to their involvement in Jewish life on campus. These incidents of hate and intimidation are widespread and impacts on campuses with large and small constituencies. They impact on Jewish support groups like Hillel and Jewish fraternity members like of AE Pi. It has even led the Simon Wiesenthal Center to create an app, Combat Hate U, to ensure individual students they can report these incidents immediately and they are not alone. Mr. Chairman, we're here today seeking the committee's help because too often university administrators have been tolerating a level of harassment and intimidation of Jewish students that they would never dream of allowing against other demographic groups because they know that until now there are no consequences. The Department of Education does not protect Jewish students the same way that it protects other groups. The failure of schools and federal government to protect Jewish students on campus from harassment is one of the most pressing issues for the American Jewish community. That is why the Simon Wiesenthal Center and every mainstream credible Jewish organization in the nation, some of whom are here today, came together last year to demand equal protection under the law for Jewish students, and as you know, that is why the Senate passed the bill unanimously. Mr. Chairman, I brought a few recent illustrations. This one posted by a professor at Rutgers University, others from University of Houston, University of California, Berkeley, I'll submit them later, that show us in real time what's going on the campuses. While this is a distressing national phenomenon, permit me to delve into the events in my own state of California. I will, instead of giving the examples that are already quoted, let me just say that the few anti-Semitic incidents, some of them that are reported at University of California, Jewish students on many campuses from coast to coast report severe, persistent, and pervasive harms at the hand of anti-Israel activists. That harassment often includes physical and verbal assaults, destruction of property, bullying and intimidation, denigration, discrimination, and suppression of speech, and often takes place regardless of the victim's personal feelings on Israel. Jewish students report fearing displaying their Jewish star necklaces, wearing their Jewish sorority fraternity letters, or sometimes even walking to Hillel for Shabbat dinner. The problem had become so severe that University of California, then President Mark Yudof, commissioned a fact-finding team to interview Jewish students on 7 UC campuses in order to objectively assess the campus climate for them. According to the team's report, Jewish students were indeed, quote, confronting significant and difficult climate issues as a result of activities on campus which focused on Israel, its right to exist, and its treatment of Palestinians. The team found that on every UC campus they visited, quote, Jewish students described an environment in which they felt isolated and many times harassed and intimidated by student, faculty, and outsiders. Despite the undeniable hostile environment that many Jewish students experienced at UC California, complaints filed under Title VI of the 1964 Civil Rights Act on behalf of Jewish students on 3 campuses, UC Irvine, Santa Cruz, and Berkeley, were unceremoniously dismissed on the same day in August 2013. Mr. Chairman, usually members of the clergy go on very, very long and look for a dispensation from the good Lord for the clock. I will instead just cut to the chase of the last 2 paragraphs. Had OCR officials use the State Department's definition in identifying the basis of the harassment that targeted Jewish students, they would have recognized the anti-Semitism at the heart of it. Instead, OCR's lack of an adequate understanding of anti-Semitism has effectively denied Jewish students equal protection under the law and left them uniquely vulnerable among their peers. That's why we ask you and your colleagues to support our request and to move this legislation forward. Thank you, Mr. Chairman.
Thank you, Rabbi. Dr. Trachtenberg, welcome.
Thank you. Thank you, Chairman Goodlatte, Ranking Member Conyers, and members of this committee. It's an honor to be here today to testify on the issue of anti-Semitism on college campuses. I'm grateful that you're soliciting a wide range of voices on this important subject because the right of students and faculty to express diverse views is precisely what is at stake in the current attempts to limit campus speech. It's increasingly common to hear reports that a new anti-Semitism threatens to engender students on a scale not seen since the Second World War and the Holocaust. Studies from several major organizations have sounded the alarm that anti-Semitism is a clear and present danger, while a number of commentators have argued that yet another war against the Jews is upon us. However, they're motivated less by an actual threat facing American or world Jewry than they are part of a persistent campaign to thwart debates, scholarly research, and political activism that's critical of the state of Israel. The truth is that the old anti-Semitism, such as we saw in Charlottesville this summer, where torch-bearing marchers carried Nazi and Confederate flags and chanted, "You Jews will not replace us," and murdered a protester, is still alive in the United States and requires vigilant and persistent resistance. Legislation such as the Anti-Semitism Awareness Act, however, is not a genuine attempt to contend with actual anti-Semitism, but rather is an attempt to quell what are in fact protected acts of speech that are vital and necessary to the scholarly missions of educational institutions and to the functioning of democratic societies. It's a factual distortion to characterize campuses in the United States as hotbeds of new anti-Semitism. A recent study by researchers at Stanford University reported that while depictions of rampant anti-Semitism are widely reported in the press, they do not represent the actual experiences of Jewish students at the campus level. They discovered that campus life is neither threatening nor alarmist. In general, students reported feeling comfortable on their campuses, and more specifically, feeling comfortable as Jews on their campuses. Much of the testimony you'll hear today is likely to argue that anti-Semitism is at crisis levels. I urge you to be skeptical of such claims. First, many of the stories that get wide circulation contain factual distortions and are misrepresented in the media. Second, many studies are based on a definition that defines criticism of Israel as inherently anti-Semitic. Rather, students who engage in speech that's critical of Israeli policy are largely motivated by their concern for Palestinian human rights. They are not motivated by anti-Semitic speech, but its opposite, a desire to end racial and religious discrimination of all kinds. It is profoundly difficult to create a definition of anti-Semitism for legislative purposes. The root of current debates in anti-Semitism lie in a seemingly intractable problem of how to critique Jewish collective power in a way that does not immediately resonate with a long history of anti-Semitism. Throughout the last 1,000 years of European history, Jews were regularly characterized as an incommensurate and exceptionalist element who sought to undermine the established religious, political, and economic order. In each of those moments, Jews were imagined as a united group that possessed power and authority far beyond their actual numbers. Yet in 1948, with the founding of Israel as a solution to anti-Semitism, the situation changed dramatically. For the first time, a significant number of Jews gained actual and not imaginary power. Today, the state of Israel has borders, police, courts, a military, a nuclear arsenal, political parties, a mostly representative and somewhat democratic system of government. Like all other states, its actions must be permitted to be a matter of public debate and discourse, both within the Jewish community and outside of it. Yet speech that's critical of Israel still strikes many as inherently anti-Semitic. The problem is we are still learning how to talk about Israel's actual political power in ways that do not immediately echo much older and anti-Semitic depictions of imaginary Jewish power. This is not only on account of the long history of anti-Jewish hatred in the West, it is also because, as we see in a legislative initiative such as these, to characterize any speech that's critical of Israel as intrinsically anti-Semitic has been a highly effective tool employed by those who uncritically support every action of Israel and seek to stigmatize all critics. It would be ill-advised for Congress to establish legal authority on a definition of anti-Semitism that is so deeply contested. To insist that Israel cannot be protested or objected to mandate that collective Jewish power cannot be analyzed or debated, or to conclude that Jews, because they were once victims of humanity's greatest genocidal crimes, are somehow immune from becoming perpetrators of violence against other peoples, reinforces the anti-Semitic belief that Jews are a fundamentally different people. Most dangerously of all, attempts to broaden the definition of anti-Semitism to encompass phenomena that are clearly not anti-Jewish can only make it more difficult to recognize, isolate, and oppose actual anti-Semitic hatred when it does appear. Thank you.
Thank you. Mr. Clement, welcome.
Thank you, Mr. Chairman. Mr. Conyers, it's a pleasure to be here. It's a particular privilege to be here representing the ADL, the Wiesenthal Center, AIPAC, and the Jewish Federations of North America. There are at least three kinds of issues floating around the room this morning. One is the extent of the problem. Two is the policy wisdom of addressing it with a clarifying definition of anti-Semitism. And the third is whether providing that definition raises problems under the First Amendment. The others on this panel are much better situated to address the first two issues, so I'll direct my remarks only to the third issue and to say as emphatically as I can that providing a definition along the lines that the Anti-Semitism Awareness Act would do does not raise First Amendment problems for three basic reasons. One is that this act is not a speech code, but simply provides a definition that will allow the Education Department to use potentially speech, but only for evidentiary purposes, in evaluating whether or not harassment is motivated by anti-Semitism. Second, that a definition here serves First Amendment values. It doesn't harm them. One way or another, government officials are going to be looking into this question, and I think it serves First Amendment values for them to have a definition that guides their mission. And third, but I think frankly least importantly, the fact that the act has a savings clause. So on the first of these points, that it's not a speech code, I think it's very important to understand that this act does not take any speech and make it illegal or impermissible. So somebody, just like they can do today, can engage on campus in the most abhorrent anti-Semitic speech, and the Education Department will not take action against them just for that. But if they couple that abhorrent speech with, say, a physical attack on a Jewish student, then this act and the Constitution allow the use of that anti-Semitic speech to demonstrate the motive of the person engaged in the harassment. And the First Amendment clearly permits that, which is to say that this isn't even controversial in the sense that when speech is not prohibited, but only is used for evidentiary purposes, the First Amendment is not offended. The Supreme Court laid down that rule in Wisconsin against Mitchell, which was a unanimous decision. There weren't that many things that Chief Justice Rehnquist and Justice Blackmun agreed on, but this was one of them. No First Amendment problem. And that's just what the definition does here. It guides the Education Department in the evidentiary use of speech to allow them to decide whether or not something is anti-Semitic. The second major reason I don't think there's a First Amendment problem here is that what we have here is a clarifying definition. And providing a definition to government officials who, one way or another, are going to be looking at speech, providing a definition serves First Amendment values. The First Amendment generally abhors government officials looking at speech with unfettered discretion. But that's essentially the status quo. Whatever Congress does here, if Congress does nothing, it is still going to be the Education Department's position that Title VI forbids harassment motivated by anti-Semitism. So the question really boils down to whether the Education Department officials are going to make that judgment without a definition or with a definition. And I certainly think it serves First Amendment values to guide that discretion. I think the one area of the First Amendment for a while that government officials had no guidance was the obscenity area, where the Supreme Court, at least for a while, famously had the "we know it when we see it" test. I don't think anybody thinks that was the finest chapter in the Supreme Court's First Amendment jurisprudence. And really, right now, the status quo is anti-Semitism. Well, the Education Department officials will know it when they see it, or at least we hope they will, because they have no guidance, no definition guiding their work. And that's what this law could change. Mr. Conyers, you made the point about being concerned about First Amendment values in this area, and I certainly share that concern. I do think, though, that the First Amendment issue in this area is largely what's the standard for harassment. If that is a hair trigger and anything that offends anyone is harassment, then I do think there will be First Amendment problems. But I take the current law to be that the harassment standard is the same standard the Supreme Court laid down in the Title IX context in Davis against Monroe. But one way or another, this law doesn't change it. So if you want to make that more demanding to protect First Amendment values, you could do that. If you want to make it slightly less demanding, you could do that. But all this law does is take whatever the existing standard is and provides a definition. Just two last thoughts. One is, I know the chairman has raised the question of why a definition here when you don't have a definition in other contexts. I do think if there were a real doubt about what constituted racist speech, or there was some argument people were using to cover racist speech, we'd want to have a definition. And in the same way, uniquely in this context, somebody can say something anti-Semitic and say, oh, don't worry about it, it was just anti-Zionist. It wasn't anti-Semitic. And so this definition really tries to address this problem. The last thing I'll say is we also have a savings clause in this law. I think that is, frankly, the least important reason, though, that there's not a First Amendment problem. Thank you.
Thank you. Ms. Parker, welcome.
Thank you, Chairman Goodlatte, Ranking Member Conyers, and distinguished members. My name is Sandra Hagee Parker, and I am here on behalf of the Christians United for Israel Action Fund. We represent 3.8 million members whose sole purpose is to stand united on behalf of the Jewish state and its people. In 2008, CUFI on campus was established, aiming to educate students about Israel and arm them with the truth, because the lessons learned in classrooms today become the policies in the public square tomorrow. And within these classrooms, intellectual discourse, academic freedom, and the freedom of speech are sacrosanct and essential to achieving tolerance and understanding among divergent groups. Despite this, with increasing regularity, Jewish students, Jewish groups, and those who support them find themselves having these sacred rights abridged. This past summer, a group of students from San Francisco State University filed a lawsuit alleging its school knowingly fostered anti-Semitic discrimination and a hostile environment which had been marked by violent threats to safety of Jewish students on campus. Student Jacob Mendel experienced hostile behavior, which was ignored by the university despite a complaint being filed. He stated, quote, "I felt scared to be a Jew on campus. I felt as if the university did not want me there because I was Jewish, and as if we weren't allowed the same rights as other organizations on campus. I felt like a second-class citizen because I was Jewish," end quote. Brian Landry, a student at UC Davis, wrote the following this past week in the California Aggie newspaper, quote, "As a Jewish student, I've seen my fair share of anti-Semitic actions on campus. I've had foul and intolerable words yelled at me while I'm studying because I had a sticker of Israel on my laptop. When Arab-Israeli diplomat George Deek came to speak on campus, anti-Semitic students shouted, 'Death to Jews,' at my friends and me. What I haven't seen is an open statement from the school about any of these events. But what's more frustrating is that due to the lack of exposure and punishment for these acts, other students don't know what happened," end quote. We cannot change what we are not willing to confront. Infiltration of this behavior without confrontation has led to its normalization. So much so that those who experience this discrimination often feel reporting it is a waste of time due to the regularity at which it occurs and complicity with which it is encountered. So pervasive is this harassing behavior that it spills over to non-Jewish individuals. Many of our CUFI students have personally experienced that mere standing with Jews or the Jewish state has resulted in the same hostility. For instance, at the University of New Mexico, a CUFI student had rocks thrown at them while tabling with an Israeli flag. They were also spit upon. At George Mason, a CUFI student wearing a CUFI t-shirt was confronted in their cafeteria, cursed and yelled at in front of several hundred students, and told that she was disgusting and a baby killer. That student is now too frightened to wear the shirt again. This behavior is not meant to provide a legitimate critique. It is harassment aimed to silence and shut down the perspective of Jewish students and those who support them. Allowing this behavior to shut down free speech is at odds with the free thinking and safe environment our nation's colleges strive to create. Students and administrators alike should be able to distinguish between a valid critique of a nation and anti-Semitic behavior cloaked as opposition to Zionism. Providing a standard by which to judge these acts no more chills free speech than the presence of a thermometer prevents the temperature from rising. Both sides of the argument deserve to be heard, but at present, one side is using the First Amendment as both a sword with which to inflict harm and a shield with which to protect itself from the consequences of its actions. Valid intellectual discourse and equal access to education should not be mutually exclusive, and the exercise of free speech is not an affirmative defense for harassment. The First Amendment does not relieve schools of their obligation to ensure that their students receive equal protection under the law. As Kenneth L. Marcus, President Trump's present nominee for Assistant Secretary of Civil Rights in the DOE, has stated, quote, "The U.S. Department of State has developed excellent tools for addressing anti-Semitism in every country other than the United States," end quote. So why not hold ourselves to the same standard? And despite Stanford's 2017 study concluding it was not a problem, anti-Semitism was problematic enough at Stanford University that its student body took it upon itself to pass a resolution against anti-Semitism, and within it included the same definition used by the State Department for guidance. Anti-Semitism is not a Jewish issue, it is a human issue. Jewish identity and ancestry continue to be a target, whether one is male or female, conservative or liberal, religious or agnostic. History has already shown us what happens when good men and women do nothing in the face of such evils. Not to act is to act. Thank you for your consideration and your time.
Thank you, Ms. Parker. Mr. Greenblatt, welcome.
Thank you. Good morning, Chairman Goodlatte, Ranking Member Conyers, and members of the committee. I am Jonathan Greenblatt, CEO and National Director of the Anti-Defamation League. I deeply appreciate the opportunity to participate in this timely hearing on anti-Semitism on college campuses. I'd like to use my time this morning to highlight the trends we are seeing, including the rise of anti-Semitic incidences on campuses and the impact of unprecedented outreach and recruitment by organized hate groups on campus, then provide suggestions and some potential responses. As the Congressman Conyers noted, the ADL has been tracking anti-Semitic incidences in America since the 1970s. Our annual audit, which we are now doing on a quarterly basis, provides a snapshot of this national problem and helps our professionals at our headquarters in New York and our 26 field offices around the country identify trends and craft responses. Data drives policy, and our audit has led us to draft the first model hate crime law in the U.S. Today, that hate crime law has been adopted by the federal government and 45 states around the country, including the District of Columbia. And the Federal Hate Crime Statistics Act of 1990 is also based on the idea that we must count each and every bias-motivated crime and teach police and communities how to respond to them. New audit data released last week, as Congressman Conyers noted, detailed a 67% increase in the first 3 quarters of this year over the same time period last year. In fact, we have already recorded more anti-Semitic incidences in 2017 than we saw in their entirety of 2016. I'm talking about acts of harassment, vandalism, and violence directed against Jewish individuals and institutions. These numbers are compiled by my team of professionals, with each reported incident verified before we log it. This is not about rumors or rhetoric. This is about hard facts. Anti-Semitic incidences indeed spiked after the Unite the Right rally in Charlottesville. Until late 2016, such white supremacists were not active on college campuses. But starting in the fall of last year, they began a much more open effort to spread their message and recruit at colleges and universities. Last year at this time, the ADL had tracked 9 incidences of white supremacist activity on college campuses. This year, for the same time period, that's 2 months into the academic year, we've tracked 80 such incidences, nearly a 10-fold increase year over year. But anti-Semitism cannot be attributed solely to extremists on the right. Neither side of the political spectrum is exempt from intolerance. We've seen a rise in anti-Semitic rhetoric coming from a radical left-wing viewpoint as well, one often rooted in extremely hostile views on Israel that can cross the line into anti-Semitism. Now, there is nothing wrong with criticizing particular policies of a specific elected government in Israel. That happens all the time, and it's not anti-Semitism. Just as criticizing policies of the Trump administration or the U.S. Congress doesn't make you anti-American. That's not what we're talking about. But whether it originates on the fringes of the left or the extremes on the right, we have seen real cases of anti-Semitism surge at colleges and universities. Our audit documented 118 such anti-Semitic incidences this year, compared to only 74 in the same period last year. That's nearly a 60% increase. Our written statement outlines a number of those incidences. I don't have time to get into them this morning, but when we identify a problem, we also believe we have a responsibility to propose solutions. Our statement highlights an effective response on anti-Semitism that we saw in the University of California system. And we believe at the ADL that the enactment of this act, legislation that was approved unanimously by the Senate, would be an important step forward to address discrimination against Jews. It would also have positive implications for Muslims, Sikhs, and members of other religious groups when discrimination is based on the group's actual or perceived shared ancestry or ethnic characteristics. As an agency that serves as a fierce advocate for the First Amendment, let me reinforce Mr. Clement's claim: this would not compromise freedom of speech, period. It would provide guidance to the Department of Education and the Department of Justice on whether to investigate anti-Jewish discrimination and instances in which anti-Israel activity crossed the line into targeted, intentional, and unlawful discriminatory intimidation and harassment of Jewish students. Our statement also provides several additional policy recommendations. Number one, first, we recommend training and outreach programs for administrators, faculty, staff, and students on best practices and protocols to respond to hate speech, extremism, anti-Semitism, and bigotry. Second, we recommend that education on the parameters of First Amendment free speech rights. Hate speech may be protected, but administrators and student leaders have a moral responsibility to address the accompanying impact. And while the First Amendment protects hateful speech, it does not allow for harmful speech intended to incite violence. Third and final, we must recognize that there are no simple, complete solutions to this problem, and the issue of anti-Semitism and all forms of bigotry must be addressed long before the college years. The government has a responsibility to provide funding for anti-bias, anti-racism education initiatives in K-12 schools to inoculate our children from intolerance before they ever get to the university. In closing, I deeply respect the opinions of the experts at the table, but let me just say, because this legislation balances free speech considerations with the surge of discrimination, the ADL and all other major Jewish organizations, the communal leadership, are unified in their support of this act. Thank you very much for your leadership. I look forward to your questions.
Thank you. Ms. Nossel, welcome.
Chairman Goodlatte, Ranking Member Conyers, and members of the committee, thank you for the opportunity to
May I want to turn the microphone on.
Thank you for the opportunity to testify today on anti-Semitism on campus. PEN America stands at the intersection of literature and human rights to protect open expression in the U.S. and worldwide. Our mission is to unite writers and their allies to celebrate creative expression and defend the liberties that make it possible. We work extensively on issues related to campus free speech. Our fall 2016 report on Campus for All, Diversity, Inclusion, and Freedom of Speech at U.S. universities sets out a comprehensive analysis of the tensions that rise from colleges' dual imperatives to make campuses hospitable learning environments for students from all backgrounds while maintaining uncompromising protections for freedom of speech. It's our view that these two missions can and must coexist. PEN America is now working with university leaders, faculty, and students around the country to help address these strains by facilitating in-depth dialogues among diverse stakeholders and promoting concrete approaches to make the campus an open environment both for all people and for all ideas. We are alarmed at the rise in anti-Semitic speech and actions on campus that fellow participants in this hearing have documented. We applaud the committee for its leadership on this issue. As an organization dedicated under our charter to both dispelling hatreds and defending the unhampered transmission of thought, we are firm in the belief that countering the spread of hatred must and need not impair free expression protections. Consistent with that commitment, we have several related concerns with the Act. This hearing takes place at a moment of pressing threats to free speech on campus, including efforts to disinvite and shout down speakers, hateful speech that intimidates members of historically vulnerable groups, and efforts to deter, silence, and punish speech. Amid these encroachments, it's imperative to avoid allowing even well-intended measures to legitimize newly restrictive parameters for expression. It's not difficult to conceive of scenarios, a model UN debate addressing resolutions targeting Israel, speeches by Israeli leftists, or an event featuring Breaking the Silence, a group of former Israeli soldiers who oppose their government's policies, in which speech could meet the definition of anti-Semitism contained in the act without being anti-Semitic at all. While such speech alone might not amount to a civil rights violation, alongside other incidents and expression, it could form part of a claim of harassment, thus subjecting the speaker to investigation and potential disciplinary action. Many college students are finding their political voice for the first time, exploring modes of activism and feeling their way to causes that they will champion throughout their lives. Students are supposed to experiment and should not live in peril that an errant political chant, speaker invitation, or remark could trigger a civil rights claim. One might argue that a rule of reason read into the act would ensure that it would only be applied where the speech in question bore signifiers of anti-Semitic intent or sentiment. But the campus environment today is highly charged. We've seen in the context of Title IX and other controversies that expression that may seem anodyne, satirical, artistic, or purely academic can trigger an intense reaction in the hothouse environment of a polarized campus. The Israel-Palestine conflict is among the most contentious subjects of campus debate. In this environment, any new weapon to counter offensive speech is vulnerable to misuse. We have seen that even claims of harassment that are ultimately judged meritless can pose enormous strain on individual witnesses, responsible administrators, and the campus as a whole. Alongside rising anti-Semitism, other forms of hateful speech are also surging. Many groups have identified slurs and insults that they believe are not fully recognized for their derogatory character. These include cartoon images of religious figures, depictions of members of historically marginalized groups by those outside of the group, and the invocation of lesser-known stereotypes or slurs. If this act is passed, we should not be surprised if other historically vulnerable groups ask for similarly expanded protections. The campus is already a minefield when it comes to speech. New, viewpoint-specific restrictions will render it even more dangerous for those who dare express controversial ideas. Finally, having reviewed the very thoughtful testimony of my fellow witnesses, we submit that we do not see evidence that the problem of rising anti-Semitism derives from the current definitional confusion, nor that an expanded definition will address the concerns we all share. While many witnesses cite similar practical measures they believe can be effective, I'm not sure any of us can be confident that this definitional change will actually help solve the problem we are confronting. Finally, the U.S.'s approach to free expression is the most protective in the world, a proud distinction. Whereas Holocaust denial is banned in much of Europe, it's considered protected speech here, best answered not by investigations or prohibitions, but by counter-speech. If the Anti-Semitism Awareness Act were to pass, the U.S.'s claim as a global standard bearer against viewpoint-based restrictions on speech would be blunted. PEN America is eager to work with the committee to advance constructive steps to help address anti-Semitism and bigotry while upholding robust protections on free speech. To this end, we've also included in our written testimony a copy of Wrong Answer: How Good Faith Attempts to Address Free Speech and Anti-Semitism on Campus Could Backfire, a new PEN America white paper that analyzes the Anti-Semitism Awareness Act as well as a recent spate of campus free speech laws in the states. Thank you again for the opportunity to testify.
Thank you. Mr. Stern, welcome.
Thank you. Thank you, Chairman Goodlatte, Ranking Member Conyers, and all the honorable members of the committee. It's my pleasure to be here today, my honor, representing the Eustace and Karen Rosenberg Foundation, which works to combat hatred and anti-Semitism with a special focus on the campus. From 1989 to 2014, I was the American Jewish Committee's expert on anti-Semitism, and over those years, I worked with many college presidents on a variety of initiatives about bigotry, anti-Semitism, and anti-Israel animus. One project was to train over 200 college presidents on a manual of how to manage campus bigotry. Every one of these projects stressed that approaches which promote academic freedom are more likely to work on campus, and those that explain it away or harm it will actually make the problem worse. Let me give you one quick example. In 2007, when the British University and College Union, the UCU, adopted a resolution advancing an academic boycott of Israel, some in the American Jewish community said Americans should boycott British academics in return. That approach, of course, would violate academic freedom because ideas should be evaluated on their merit, not on the nationality of their proponents. I worked with over 400 university presidents who signed the New York Times ad that essentially said if the UCU was intent on violating fundamental academic principles and dividing the academic world into two, Israelis who should be shunned and everyone else, then count their universities as Israelis too. That approach worked because it underscored the importance of academic freedom and free speech, and I dare say not one president would have signed an ad that said, let's do a counter boycott. And that's one of my main concerns about the Anti-Semitism Awareness Act. By undercutting academic freedom and free speech, it too would do great harm to the academy and to Jewish students and to faculty teaching Jewish and Israel studies. I was the lead drafter working along with my colleague Andy Baker, who did the great politicking of the working definition of anti-Semitism, on which the State Department definition is based. It was drafted, as Rabbi Baker said, with European data collectors utmost in mind, and not to chill or regulate speech on American campuses. In recent years, some Jewish groups and individuals began filing Title VI complaints based in part on assertions that anti-Israel expressions transgress the definition, and when all those cases lost, they tried to get the University of California system to adopt the definition, and when that failed, they turned to lawmakers. As a Jewish communal official acknowledged, this type of legislation would open the door for other groups to seek legislatively enshrined definitions too. Let's imagine African-American groups asking for a definition of racism for consideration under Title VI, targeting political expression deemed racist. Would it include opposition to affirmative action? Would it include opposition to removing statues of Confederate leaders? Imagine a definition designed for Palestinians. If denying the Jewish people the right to self-determination is anti-Semitism, then shouldn't denying the Palestinian people the right to self-determination be anti-Palestinianism? Furthermore, there's an internal and frequently distasteful debate in the Jewish community as to who is included in the family and who is not, based on whether they are Zionist. We know for sure, and we've heard today of Jewish students who are Zionists who have sometimes suffered and suffered severely, but Jewish students who are anti-Zionists have been called traitors, have been called capos by pro-Israel Jews, and told they're really not Jewish at all. Now, whether you can be an 18-year-old anti-Zionist and inside the Jewish community is not a debate that Congress should decide, but by adopting this definition, Congress would do so by labeling anti-Zionist Jews anti-Semites. Additionally, in the last few months, we have seen students exercising a heckler's veto over speakers considered conservative or racist. Support for Israel is seen on some campuses in a similar vein. Congress should not be creating something akin to a presumption that if a pro-Israel event is targeted, it's because of anti-Semitism rather than political disagreement. The focus on Israel also ignores other challenges to Jewish students today, such as alt-right campus organizing, and the mistaken views that because Jews are largely white, they cannot be victims of hatred. Here's what concerns me most. Some groups, empowered by a congressional endorsement of the definition for campus application, will hunt speech they believe transgresses it and then press administrators to either suppress it or condemn it, threatening Title VI cases. We want administrators and other campus officials to conduct surveys on campus climate, to offer full semester classes on anti-Semitism, to find new ways to use education to break down the binary thinking around the Israeli-Palestine conflict. We want universities to cultivate an environment in which all students, Jews included, feel comfortable saying what they think, even if their ideas are not fully formed and they might be wrong. But when an administrator is effectively told, as they will be by the general councils, that they will be evaluated on how well they police and react to anti-Israel political speech, that will likely be their only focus. As we've heard today, the working definition was recently applied to campus in the United Kingdom. Let's see how that worked out. An Israel Apartheid Week event was canceled as violating the definition. A Holocaust survivor had to change the title of a campus talk after an Israeli diplomat complained, and most disturbing, an off-campus group got a university to investigate a professor for violating the definition. In an article she had written years ago, the university ultimately found no basis to discipline her, but the exercise itself was chilling and McCarthy-like. My fear is if we similarly enshrine this definition to law, outside groups will try to suppress rather than answer political speech they don't like. The academy, Jewish students, and faculty teaching about Jewish issues will all suffer. Thank you very much.
Thank you, Mr. Stern. We'll now begin with the questioning of the witness, and I recognize myself. Rabbi Baker, you write in your written testimony that if we are to be successful in combating anti-Semitism, we must first understand it, we must define it. It is a complex phenomenon. It has changed over time. It presents itself in both new and traditional forms. To some, however, that the phenomenon of anti-Semitism changes over time, presents itself in different forms over time, would counsel against codifying any particular definition of anti-Semitism. How is a definitional codification approach compatible with a concept of discrimination that changes over time?
Thank you, Mr. Chairman, for the opportunity to expand on this. The fact is that there is, I think, a core understanding of what anti-Semitism is about. But the way it's manifest, the way people encounter it, will vary from time and place. It does not mean that one day to the next it has changed or would change dramatically. I think the idea of a definition, and in fact this working definition that was developed first with great difficulty to achieve consensus among Jewish experts and organizations around the world, and then to find its use in the EUMC and in other bodies in Europe, really began with acknowledging those traditional aspects of anti-Semitism. They may, as Dr. Nadel said, wax and wane over time. We understand them, but we should explain and define them for people to be clear on this. The idea of conspiracy theories against Jews, what other elements motivate this hatred, but also to recognize, as we've seen in more recent times, for example, Holocaust denial is itself a form of anti-Semitism. Wouldn't have been part of a definition a century ago, but it's critical now. And finally, when we speak about anti-Semitism as it relates to Israel, and I think that is something more and more people have come to recognize, not just Jews who've experienced it in Europe or now here in the U.S. and on college campuses.
Let me interrupt since I only have 5 minutes, but thank you for that.
You're welcome.
I get your message. Dr. Nadel, I was pleased to see that Kenneth Marcus, an advocate for the use of the State Department's definition of anti-Semitism in addressing anti-Semitism under Title VI, was nominated by the President to head the Civil Rights Division of the Department of Justice, which would enforce Title VI. I expect, and I guess I'll ask if you expect, that Mr. Marcus, if he's confirmed to that position, would use the State Department's definition of anti-Semitism in addressing anti-Semitism under Title VI, and if so, might it be best to wait and see the results of using such a definition before Congress were to codify it into statutory law?
Thank you, Mr. Chairman. I very much agree that I think it would be very useful to find out how this is going to be applied in different situations rather than passing legislation to decide something that we don't know how it will play out. So I agree with you. I think your suggestion is a good one.
Mr. Greenblatt, would you care to comment on that same question?
I think we need to keep in mind that the attempt to ensure that Mr. Walker or Mr. Marcus, or other officials simply can consult the definition would make it easier for them to do their job effectively. So rather than having Congress wait, I would encourage you to proceed expeditiously with this process so that Mr. Marcus can be an effective advocate and public servant at the Department of Education.
Dr. Trachtenberg, Rabbi Baker wrote in his written testimony that unlike anti-Semitism, other forms of prejudice and group hatreds are easy to recognize. Do you, or any of the other panelists for that matter, disagree with that? That is, can't and don't all forms of hatred change with the circumstances and the times?
Thank you for your question. I think we always have to pay attention to context when we're looking at any particular one incident, and we need to investigate it carefully. When we think about the State Department definition, which seeks to codify what anti-Semitism is, it's such a flawed definition that it can virtually encompass any particular act without any real regard for context, although it pretends that it does. For example, the State Department definition claims that stating that a particular Jewish person has more loyalty to the state of Israel than they do to their own country is necessarily an example of anti-Semitism, where the truth is that that's one of the fundamental premises of Zionism. And if you go back and look at the statement, say, of Theodor Herzl, who's wrote really what's considered the founding text of Zionism, he argued very clearly that Jews are one people, and therefore it's useless for them to be patriots to the countries in which they reside. So there's times when a statement like that is contained in the definition of the State Department would actually undermine the founding premises of Zionism itself.
Thank you. My time's expired, but Mr. Stern, I was intrigued by a portion of your testimony that I don't think you talked about in your oral testimony, and that is, would you elaborate on the points that you make with regard to something you call Pandora's box?
Thank you, Chairman Goodlatte. And the issue is that once you open up this capacity for having an official definition, then I suspect any organization that represents other groups that are concerned with things on campus will want a definition too. I mean, again, look at affirmative action, as I mentioned before. If somebody on campus says there should be no affirmative action, you could understand how an African-American student might hear that as, I don't really belong here. And that's something that the university should take responsibility for in looking at the campus culture. But you'd have groups, I would think at that point, saying, wait a minute, this is an indicia of something that makes students feel uncomfortable. We want to codify that too. Under Title VI, the OCR should look at that as an indicia specifically. And I think you could find other types of examples with other types of groups
But my
down the
time's
road.
expired, so I don't think we're going to do it this
But
moment,
that-
but I get your
that's a major
point.
Mr. Chairman?
Yes,
if
Rabbi Cooper.
If I may, I just want to bring back to focus as to why we're here this morning. The United States, through its agencies, has failed many Jewish students who went through extreme situations of anti-Semitism. We're here because we need your help to address that. And I think that needs to be a focus. Secondly, just with permission, the idea that a dual loyalty or being more loyal to a state other than the nation that we've been born into is inherent in Zionism, which was just stated by another speaker, cannot go unchallenged. It is simply, it's not true, it's not accurate, and it is cannon fodder for anti-Semites.
Thank you. The chair now recognizes the gentleman from Michigan, Mr. Conyers, for his questions.
Thank you, sir. This has been a very unusual situation. As an African American, I keep thinking about what if we were looking at the question of race from this perspective. And I have 4 questions here, but I think instead I will just ask each one of you who chooses to take just a few sentences to sum up any last considerations that you would leave the House Judiciary Committee with. And I'll start with you, Rabbi Baker.
I think the Anti-Semitism Awareness Act would provide guidance that would explain what anti-Semitism is about to people who need to know. It would go beyond what you mentioned, Mr. Conyers, in the 2010 guidance that potentially can be changed in a new administration that would underscore the fact that Title VI should be used to address anti-Semitism on college campuses.
Dr. Nadel?
Thank you. I think the Anti-Semitism Awareness Act is problematic. If there is a way to see it referred to with Kenneth Marcus, then perhaps that is the way to go. But for now, it will label anti-Israel actions on campus as anti-Semitic, and it will quash free speech. And that's a mistake.
Thank you. Rabbi Cooper.
Congressman Conyers, we know each other for a few decades, and just to summarize, the American Jewish community, wall to wall, is here this morning because we need your help. And as a leader in the civil rights movement, and along with the chairman, we're here because we have a defined problem. You've heard the statistics from the Anti-Defamation League. They're quite shocking. What's happening here is happening in real time. And those who refuse to recognize the problem of anti-Semitism Well, it's kind of like inviting people from the Flat Earth Society to a hearing about NASA.
Thank you. Dr. Trachtenberg.
Thank you. What I would say as a comment that I hope you leave with today is to listen seriously, please, to what the faculty who work in the field of Jewish studies are asserting. What you've heard from the president of the Association for Jewish Studies, who sits to my right, as well as from myself, and from many, many other faculty members who have studied this issue very, very carefully using rigorous scientific methods, that the question of anti-Semitism is a highly contested one. And it's a topic that we do not believe that should be addressed with the Anti-Semitism Awareness Act. And I think you should trust professors and universities to contend with these issues as they arise on their campus and allow us to teach our students unimpeded. Thank you.
Thank you, sir. Attorney Clement.
Mr. Conyers, I would just like to follow up on your analogy to the race context. And I would think if we had a dynamic on our college campuses where we felt like the existing Title VI prohibitions against harassment on the basis of race were being under-enforced because people kept on saying when they were accused of harassment on the basis of race that they had some white supremacy symbol and that this wasn't anti-African American, but it was all in service of this symbol, that if we had a consensus that that was wrong, that we could amend the definition and restore an adequate prohibition on harassment on the basis of race, and it wouldn't raise First Amendment problems because it would only be triggered by harassment.
Thank you. Chairwoman Parker.
Thank you, Ranking Member Conyers. I would just like to underscore that while I understand and appreciate that academics study the problem, it's our students who are living the problem. They're the ones that are having the rocks thrown at them. They're the ones that are having the vitriol spoken to them. And the academics of Stanford did an extensive study that said, for the most part, Jews felt safe. The students of Stanford took it upon themselves to pass a resolution doing large in part what we're advocating here for today.
Thank you. Attorney Greenblatt.
I'm not an attorney, Mr. Conyers, so let me dispel that. That potential.
Director Greenblatt.
What I would simply say is that the Anti-Semitism Awareness Act, from a First Amendment perspective, will not squash free speech. It will not chill freedom of expression. But I would also encourage you, as you reflect upon the views of academics who live with the privilege of tenure in the ivory tower, and listen to those of us who work on Main Street, the ADL, the American Jewish Committee, AIPAC, Jewish Federations of North America, all the major Jewish communal organizations support this legislation.
Thank you. Director Nossel.
Thank you. That we agree that there's a serious problem doesn't mean that the solution right in front of us is the correct one. I think here we have to keep in mind the law of unintended consequences. We risk fueling the fire of contentious debates and opening the door to other restrictive measures that would chill speech, even if they don't violate the First Amendment. We have practical measures we all agree on that can be reinforced, and that's where I would suggest that we focus.
Thank you. Director Stern.
Thank you. 5 quick points. One is I agree with Mr. Trachtenberg that, or Dr. Trachtenberg, that you should listen closely to the people that are teaching on the campus, especially on these issues. They're the ones that I think have the closest feel of the pulse. Secondly, this type of legislation, I think, will be a black hole. It will suck away all the other things that we really want campuses to do to deal with their environment, to deal with their teaching. This will be the preferred answer and the focus rather than all those other things. Third, I think Jewish students are suffering in many places around the Israel-Palestine conflict because there's a great binary. Justice is seen all on one side or all on the other side. Legislation like this, rather than breaking down that binary, will add to it to the detriment of Jewish students. Fourth, I disagree with something in Rabbi Cooper's written statement where he talked about protecting vulnerable Jewish students. I teach on the campus, too. I've taught a class on anti-Semitism at Bard College. I don't think the Jewish students that I come into contact feel themselves as vulnerable and want to be protected. They want to be engaged and have their thinking shaken up by having the full capacity to look at these issues from every possible way. And fifth, I really worry about the instinct to monitor speech. We've seen outside groups creating dossiers online. We've seen what's happened in the UK. If I'm a Jewish studies professor and I'm going to be monitored for whether I teach something that transgresses this definition, I'm going to say, why should I bother? I'd rather teach about 18th century Judaism rather than Jews today, and that's going to be harmful.
Thank you all. I'm going to examine this conversation we've had this morning very carefully.
Thank you, Mr. Conyers. The chair now recognizes the gentleman from California, Mr. Issa, for 5 minutes.
Thank you, Mr. Chairman. Rabbi Cooper, in your experience, have you had, but I'm assuming you have, experience discussing with college administrators a response to these anti-Semitic incidents, and what have you learned?
Well, we've had at our Museum of Tolerance in Los Angeles a lot of interaction with primarily California-based UC and Cal State administrators, people up and down the line, including some of the campus police. There's been a lot of exchange. There have been seminars and discussions. What has been lacking, and what we've heard back from people who've, let's say, been burned once or twice by incidents that they didn't anticipate, is they lack a context. They're looking for a basic definition to give them a context on campus to guide them. In my written and verbal testimony, I spoke at some length about President Yudof when he was the head of the UC system, spent an enormous amount of time on this problem, not because it was theoretical, but because the students at the bottom of all of this were not being protected by the system. And he tried, I think, mightily to come up with ways to begin to correct that situation. But the fact that we're here today before this important group of legislators here in the House indicates that we do need help. That context, as Mr. Clement so brilliantly presented it, simply is that as a definition that will help trained college administrators, chancellors and the rest, to apply the existing context and rules to a situation in which Jewish kids have been subjected to the kinds of behaviors that brought us here today.
Well, so you wouldn't say that that there's an unwillingness to protect, but a lack of training? Is that a fair assessment? Because I see it as most of the administrators are not taking measures to protect.
I think that a lot of administrators in their own training never heard the introduction of the term anti-Semitism along all the other areas of protected groups, minority groups, gender groups that have to be protected. It simply never entered the lexicon until these incidents came forward. And it was clear from our interaction with the people, and let's give them the benefit of the doubt, that they were well-meaning and wanted to address it, didn't really know where to begin. In addition, there are many individuals on campuses, on various levels, who actually believe that Israel is an exceptional state, i.e. an apartheid state, a racist state, guilty of all sorts of crimes, in which their own personal biases do enter in to the way in which they respond to situations on campuses. But overwhelmingly, I don't think it's ideologically driven. I think it's something that's relatively new. They're not quite sure how to proceed.
Well, Rabbi, it's been a long time since I went to college, but in those days it was a simpler time. This would have been very clear. Yeah, don't look at me as how much simpler. But it was a simpler time. We would have looked at it. We'd had the 67 war. The 73 war actually occurred during my college period. Today it seems like we're involved with lots and lots of issues, every sort of politically correct speech and so on. How do we in Congress initiate a process that prioritizes the unique characteristics of anti-Semitic behavior, lest we begin a process and end up caught up in the dozens of other politically correct things that we sometimes talk about, how people refer to people? Somebody can refer to a woman in an incorrect way, another race or religion in an incorrect way, and they're often categorized as though all of them are equals, and none of them are good, but how do we in Congress initiate a process that put a priority on this type of hate speech based on its history and its pervasiveness?
I would just make 2 points, and perhaps also Mr. Clement would want to. The 2 points I would make is, number one, we're not looking to put the Jewish student at the head of the line. We're looking to include Jewish students within the context of the commitment on every campus against intimidation, creating a place where you can exchange ideas. And there isn't a single organization represented here that is ever handed the State of Israel a moral blank check for specific actions or policies that it's taken. So I think that's simply a false issue. The other point here also is for us to understand it is a more complex time, and a lot of these controversies are part of global campaigns against the State of Israel, against the Jewish people. They're sort of parachuted into campuses, which is one of the reasons why so many university administrators seem so clueless about how to deal with it. But when you have, God forbid, the next outbreak, and we pray it won't come, in the Middle East, especially now with social media, but even before, the same mantras that you'll hear on the streets of Gaza, you will hear on the campuses, and those attacks won't be about Israel. They'll be talking about Hitler was right and death to the Jews.
Thank you.
The chair recognizes the gentleman from New York, Mr. Nadler, for 5 minutes.
Thank you. Mr. Stern, it is clear to me, at least, and I've been following this for a good long time, that there's a real problem on some campuses. And I think most people would agree with that. But the Anti-Semitism Awareness Act would require only that the Department of Education consider. It says the Department of Education shall take into consideration the definition of anti-Semitism as part of the department's assessment of whether whatever was going on was motivated by anti-Semitic intent. Supporters note that the definition is not dispositive of whether Title VI has been violated, and that therefore that should eliminate any concerns about a chilling effect on free speech. What is your response to that?
Here's your microphone.
My response is that inherently is disingenuous. When you prioritize a certain definition, it has the weight of having Congress behind it compared to any other definition they can consult. And, when I'm really not as concerned, although I am, about the 2, 3, or 4, or 5 cases that may come up under this, I'm more concerned about the day-to-day impact on the campus by the fact that administrators will be told to look at this and monitor speech and people from outside, as they have with these early Title VI cases, and with these websites focusing on dossiers of professors and students, will say, hunt this speech, and if you can't suppress it, like the Israel Apartheid Week type of thing, you ought to at least condemn it. So you will give incentives to chill speech, when I think on campus what you really need is to cultivate an environment that does exactly the opposite, that brings out all the different sides of the conflict and
Counter speech.
Counter speech, and to use education to do it.
Now, so would it ever be appropriate for the federal government to define anti-Semitism for the purposes of Title VI?
I don't think so, or for any other type of bigotry, because then
So it's not that this definition is too broad. You don't think there should ever be a
I
definition?
think there are problems with the definition using it for campus because, again, denying Israel the right to exist is something you don't want to have in the venue of the UN for the president of Iran to say, and that should be objected to. An 18-year-old on a college campus who's trying to figure out, a Jewish student, whether I'm Zionist, whether I'm anti-Zionist, whether I'm tribal, whether I'm universal, they have to have the right to explore those ideas.
Now, without referencing a definition in the law, how should the Department of Education identify and investigate anti-Semitism and enforce Title VI?
I actually brought a case when I was at AJC for high school students in Binghamton, New York, the Vestal School District, where the kids were being harassed. It had nothing to do with Israel. But I can tell you, nobody asked me to look at the motivation of what these people really thought about Jews. Nobody looked at the definition. What they looked at was whether these kids were being identified as Jews and harassed as Jews, and they were. Wisconsin v. Mitchell basically says the same thing. It's not the motive that's the problem. It's the selection of somebody to be a victim of in a particular circumstance. And I think that's how you approach it.
In the last 7 years since the DOE issued its guidance, how would you evaluate the department's enforcement efforts regarding anti-Semitism?
You know, you're talking about specific cases. I think the cases that at least I was aware of had problems. They certainly had some indicia of actions that were problematic, but they also relied very heavily on protected speech. So I have no capacity at this point to say at a particular case they should have done something differently on those cases. And those cases that were brought, again, contained complaints about classes, about text, about campus speakers, about other programs. And I think they were rightly concerned about finding Title VI violations on those situations.
Thank you. Mr. Clement, if enacted, what protections would the Anti-Semitism Awareness Act provide for students on campus that are not already provided for under current law?
I think, Mr. Nadler, they would provide the protection of having the enforcement agency empowered with a definition. So I don't know that this is...
The enforcement agency could do whatever it could already do, but they would be guided by definition.
That's right.
Okay.
That's right. And I think it would facilitate the whole
Thank you. Let me go on to
process.
the next question then. Critics of the Anti-Semitism Awareness Act argue that even if you're correct that the Anti-Semitism Awareness Act does not violate the First Amendment, it could still have a chilling effect on political speech on campus. How would you respond to that?
I would respond to that by saying the key to ensure that Title VI, not just for anti-Semitism, but for all of the things that it prohibits, the key to making sure that it doesn't have a chilling effect on speech is to make sure that the test for harassment is sufficiently robust and consistent with our First Amendment values. But the rest of it, I think, is mistaken. I mean, when you say that this is going to stop, when someone suggests that this is going to stop a professor from lecturing on a topic in class, that just mistakes what the standard is for finding harassment under Title VI.
Lastly, Mr. Stern, Mr. Clement argues that the Anti-Semitism Awareness Act does not raise constitutional concerns because it contains a saving clause, more importantly because it addresses conduct like harassment rather than protected speech, and simply adds a definition to an existing prohibition in the law. How would you respond to that?
I would say two things. First, I disagree because in the application of it in particular, it'll be problematic. As Mr. Clemens has also said, the saving clause are pretty much useless, as Suzanne Nossel has said as well. And I would encourage, I know the Foundation for Individual Rights in Education has also done a very thorough analysis of this. In my view, they're the experts on this, and they've concluded without question that this would be unconstitutional.
My time has expired. I thank you.
Thank the gentleman. The chair now recognizes the gentleman from Florida, Mr. Gates, for 5 minutes.
I thank the chairman, and I'd like to begin by bragging about my state of Florida. I'm so proud that in response to some of the student government associations endorsing the BDS movement, the state of Florida passed legislation that divests our state of any entities that are participating in the BDS movement. That legislation built on the landmark work of my colleague, Mr. Deutsch, during his service in our state legislature when he ensured that our state divested from companies that were engaging with Iran and their nuclear program. Rabbi Cooper, I want to drill down specifically with you, since you mentioned student government associations. Are there any commonalities, methods, tactics, practices that groups are using to influence student government associations to pass BDS resolutions? And to what extent would those methods or tactics be impacted by the Anti-Semitism Awareness Act?
Well, I'm not an expert on the student associations, but when you read about what's going on, by the way, not only in the United States, but also what's going on in Canada, in which you have activists who are exercising the First Amendment rights, let's say who are anti-Israel, have a pro-Palestinian agenda, they get involved with student government, they stay involved, and in many times they have leadership roles. Where this act would help is when Jewish students are called out at meetings of the government, of the student government, including at UCLA, not small colleges, up in Canada as well. When Jewish students are called out and they're basically told you don't belong in student government because, if, in effect, it's dual loyalty. You don't really have a loyalty to the United States. Your loyalty is to a foreign entity, Israel, and therefore you should be booted off the board. And there are other, obviously, kinds of actions that can be taken in terms of funding. Certain kinds of speakers will get it, certain activities will get it. But I would say, overall, that if it was just a matter of student activism, then the most important message we can send through Hillel and AEPI and all the other groups is make sure Jewish kids stay involved in student government. But when you have, as we have now had numerous examples, where Jewish kids are called out and say you don't belong here because you're a Jew, that's exactly why we would, that student would be able to go to an administrator and, if necessary, to the Department of Education to get redress.
Mr. Greenblatt, from the Anti-Defamation League standpoint, how do you parse that distinction between legitimate advocacy that we can combat with other legitimate advocacy and speech that would run afoul of this act?
Thank you. I think it's really important to keep in mind that all this legislation does is require, in the plain language of the definition, be consulted by administrators when a case is brought. This doesn't mandate that they do anything. This doesn't handcuff them. This doesn't limit free speech. It simply says when an issue is brought to their attention that they consult the definition. Now, again, I think as stated by another one of the witnesses, they would need to determine that there is indeed harassment taking place. But having a definition that codifies what is indeed a very complex problem wouldn't in any way, shape, or form prohibit or, again, handcuff an administrator to prevent free speech.
I found the data that you've provided in your written testimony regarding the frequency of anti-Semitic events rising, particularly troubling on college campuses. To what extent do we tie that solely to the activity on a college campus versus perhaps some nefarious forces influencing students as early as high school? Because I'm starting to see more and more folks advocating for BDS-type advocacy, which in my mind is modern-day anti-Semitism at the high school level. Are you able to draw a nexus there?
So, Mr. Congressman, I think that's a very good and I think it's an important question. So there are two parts to it. To the first part, if we try to understand what's the causality in the increase in anti-Semitism, I think extremists from both sides feel emboldened for different reasons vis-a-vis the political climate. And so that's creating the conditions in which we're seeing an uptick in activity. And that isn't something that's a function of some academic treatise. That's the reality and what we're seeing all around the country. But to your point, yes, I would agree that anti-bias, anti-hate content in schools, particularly at the high school level, can be an antidote to intolerance, and that is another area that I think we should explore.
Thank you, Mr. Chairman. I yield back.
Chair, thanks, gentlemen. Recognize the gentlewoman from Texas, Ms. Jackson Lee, for 5 minutes.
Thank you very much, Mr. Chairman. To the ranking member, this is a very, very important hearing, and I clearly, Rabbi, I think it's Cooper important that students are young people and that any language that particularly suggests they don't belong here, I believe we're obligated to protect them and to protect their space of learning. So you have me committed on the idea that our young people must be protected. So as I query, I'm trying to find the comfort level, Mr. Stern, on the idea of the protected speech. And I graduated from the University of Virginia Law School. You can imagine my horror as I talked to the president of the university just a week ago to reinforce the horror that occurred as they came uninvited to the campus and walked along a very sacred area for students, while those students who had arrived early were looking out of their dorms or windows or standing on the front lawn. Anybody knows the structure of the University of Virginia, in complete horror and fear. I imagine amongst those students might have been Jewish students, African American students, Hispanic students, and others. And how how tragic it is that rather than words of comfort, of course, there were words that came from the highest ranking office in the land that there were good people on both sides or both sides had violence. So I think it is important that we use our approach to also be teachers, because at the same time, a young student at American University who became the first African-American student happened to be a woman, president of student government, and then there was a series of hanging nooses and bananas to intimidate. And so I think the question in this day and time is, how do we educate and protect our students and provide free space and free speech for our academics? So let me go to Mr. Clement, who is raising the legal arguments here. Mrs. Stern made a valid point of the hunt. And so I would not want to have a professor feeling that they were hunted if they had several viewpoints that I don't agree with, but several viewpoints of the issues dealing with Israel, i.e., denying the Jewish people the right to self-determination and saying they should not have their own land, and as well other criticisms that would be waged against Israel but could be waged against others. So how would I protect that professor who wants to engage in a deliberative and maybe provocative lecture, and who may be either overtly or hidden have some negative views, conspicuous or non-conspicuous views about Israel, and they're in an academic setting?
Well, Representative Jackson-Lee, I think that there is no fundamental incompatibility between free speech and free space, and I think the critical question in determining where to strike that balance is, what do we think constitutes harassment, and what do we think constitutes just free speech? And under existing law, as I understand it, there's a pretty demanding standard before we treat something under Title VI as harassment. But under Title VI, there's two questions. A, is there harassment that rises to that level? And then second, even if there is, was it motivated by one of the forbidden bases under Title VI, race, sex, national origin? And the department has taken the position that anti-Semitism is a forbidden motive. And really all this legislation—
And does that tie to criticism of a country? You don't have a right to exist. You don't have the right to your own land. Israel shouldn't exist.
And there's a variety of ways to try to define that term. This is the same definition, obviously, that the State Department has already approved. And I think, and I don't mean to dodge the question, but I think the way to protect free speech is in part to make sure we have the right definition for harassment. But once we have that, boy, it seems hard, at least from a First Amendment standpoint, to think that it's better to not have any definition of anti-Semitism, especially when it's obviously a contested term, and especially when at least some people seem to be taking cover and say, I can do anything I want, and I don't have to worry about being labeled anti-Semitic because I'll just be able to say, no, I'm just anti-Zionist.
Mr. Greenblatt, could you quickly just, I have participated in your anti-hate outreach with the Anti-Defamation League. I think they're some of the best in the country, and I also believe very quickly, or very keenly, and I'm going to ask Mr. Stern a question, so I'm going to end quickly. I thank the chairman for his indulgence. But I truly believe the investment in K-12 is crucial, and that the crisis of America is that we're not teaching anti-hate in the early years, as told to me by an African-American family that went to McDonald's, and another child who happened to be white, a little child, looked at them in horror and was afraid of them as they came into the McDonald's. How can we deal with that? And then finally, Mr. Stern, if you could finish by your answer to the Hunt question, and how do we protect these students dealing with legislation like this, which I hope to consider. Mr. Greenblatt, would you quickly answer that?
Thank you very much for the question. I would say quickly, number one, let's be clear, this definition does not prevent students or faculty or administrators from criticizing particular policies of the Israeli government. It doesn't do that. It simply defines when it becomes indeed anti-Semitism, which indeed often happens and needs to be dealt with. With respect to training and education, Congresswoman, I couldn't agree more. We need to, as a government, ensure that at all levels, our kids are immunized from intolerance at the earliest age. It is an ounce of prevention really can go a long way to dealing with this disease of bigotry.
I abhor.
Gentlelady's time has expired.
Mr. Chairman, I appreciate the
Gentleman from Mr. Stern could answer the question.
I thank you. I abhor anti-Semitism, and so I don't want to foster it. I want to stop it.
Right. Thank you. And very briefly, one thing I put in my written testimony is that I've worked with various college presidents over the years. The first manual that we put out, there was a situation that came up, hypothetical, this. A banner is put out of a window that says, you know, so-and-so, you fill in the blanks, not welcome here. There's no policy against banners out of dorm windows. What do you do? And the president of New Paltz said, I would put out a larger banner from my office saying, everybody welcome here. We want in those situations, we want anti-Semitism classes so students can understand what we're talking about as opposed to having a definition sitting on high. We want programs to give students the capacity to discuss these difficult issues when their senses of identity are wrapped up in something of perceived social justice. We want to use education as much as possible. What I worry about the hunting situation is it's going to chill speech, faculty members for sure, but also think about students. When I was working at a national Jewish organization that had a pro-Israel policy, and I'm a Zionist, I was mostly concerned with those students who were supporters of Israel. As a college professor, I'm also concerned about Jews that are anti-Zionist, and they're left out in the cold here and in fact made targets. We have websites that go and hunt them and put dossiers on there. I think this will only encourage that type of activity.
And the gentlelady's time has expired, and I now recognize the gentleman from Arizona, Mr. Biggs, for 5 minutes.
Thank you, Mr. Chairman, and I appreciate all the panelists being here today. This has been a very interesting and important topic, and Dr. Trachtenberg talked about the potential for this definition to be interpreted overly broadly, and Mr. Greenblatt talked about this is a consultative definition, and so I would like to talk specifically about the definition or inquire specifically about the definition, and I'll go to you, Mr. Clement. Providing a definition may be a good idea and may be consistent with the First Amendment as you've argued and testified to today. My question is this the right definition? Is it potentially, as some have indicated earlier in their testimony, is it potentially vague or can be interpreted overly broadly? Or is it clear and concise enough? Could it be worded better? If so, how? So if you could, your opine on that, please.
So thank you for the question, Representative Biggs. I would say that there are probably other people on the panel who are better able to sort of have a debate about whether it's, exactly the right definition. I'm not sure that, that it's necessarily the Platonic definition. I do think, though, that it has the virtue of being a definition that the government is already using. As one of my sort of co-panelists said, it's a bit ironic that we're essentially willing to use this definition with every country on the planet except ours. But I guess the one thing I really have uniquely perhaps to contribute from a First Amendment perspective is, especially given that it's just a consultative definition and doesn't purport to be the definitive definition. In the law, sometimes you have definitions that say the following term is, and sometimes you have definitions that say the following term includes. And this is more in the softer second version. I think particularly because it has that character, it sure beats the alternative from a First Amendment perspective, which is no definition at all.
Right, and I appreciate that, and I guess that's my question. Does anybody in the panel think they have a better definition than this definition? I'm inquiring of the entire panel, and by your silence, Mr. Trachtenberg, Dr. Trachtenberg.
Happy to speak to that. It's not clear to me that.
Your microphone.
Sorry, it's not clear to me, as Mr. Stern said, that a definition is required in this way. I teach entire courses on anti-Semitism, and they go on for 15 weeks. and we talk about this shifting definition of anti-Semitism. You know, in the past, it was based on religious assumptions about Jews as Christ killers, and in the Middle Ages, Jews were repeatedly accused of seeking to re-crucify Christ through all sorts of different methods, and it led to anti-Semitic caricatures of Jews. There are questions about Jews' sexuality, whether Jews were even human beings or not. In the modern period, we saw it as about racial distinctions of Jews. You know, are Jews fundamentally and biologically different? We saw it grounded in notions of race. There are questions of Jews as capitalist schemers or revolutionary subversives. So this is what we teach to our students. So settling on one definition that's going to apply to all circumstances is just too broad and too vague, and should not be the basis of legislation.
But, I mean, I don't want to get into debate with you because I have other questions asked, but I mean, one of the things you've said previously today is that this is a very broad definition. Well, if you're going to make a definition, it would seem to me that's consultative in nature, it would by its nature become a broader definition that would allow for the movement of society as we see the impact of that definition as they're using it as a consultative idea, as opposed to a very strict, binding, concise definition, which is why I was asking if there's any better definition that may be out there. Time goes by fast in 5 minutes, but I was going to come back and ask, and I'll ask Mr. Clement and anyone else as well, do you know of any judicial opinion that provides a definition of anti-Semitism, even if not in its holding in its dicta?
I have not come across such a definition.
Okay. All right. And so I guess I'm going to go ahead and yield back the balance of my time since I'm down to 10 seconds.
And I thank the gentleman. I now recognize the gentleman, Mr. Deutsch from Florida.
Thank you, Mr. Chairman. First of all, I introduced this bill because I met with the Assistant Secretary of Education for Civil Rights and asked how many investigations, ongoing investigations into cases of anti-Semitism were they pursuing? And the answer was 0, number one. Number two, I appreciate all of the academic discussion and the references to the definition. Let me just read it for the record. Anti-Semitism is a certain perception of Jews which may be expressed as hatred toward Jews. Rhetorical and physical manifestations of anti-Semitism are directed toward Jewish or non-Jewish individuals and or their property, toward Jewish communities, institutions, and religious facilities. That's the working definition, then goes on to include contemporary examples and a fact sheet. Let me address some of what we've heard today. One, criticism of Israel any criticism of Israel would be anti-Semitic under this. It's not true. Everyone understands that that's not the case. That's number one. Number two, that Jews, because once they were victims, are immune from criticism. One, while I'm offended by that, that has nothing to do with this piece of legislation. Three, that somehow this is really some effort to go after Jewish anti-Zionists is the reddest of red herrings. And four, the suggestion was made that we have to look at all different sides. There aren't all different sides to anti-Semitism. There aren't. And the comment that was made that I find the most compelling is that a college campus is where students are trying to find their voice. I could not agree more. But here's the question. In all of this talk about free speech, which we hold dear and which we have to be careful this legislation, any legislation, would not violate or curtail. In all of that discussion, what's been missing is a discussion of the free speech of Jewish students who do not feel free to speak out. They don't feel free to support Israel openly. They don't feel free to join student government and talk about their Judaism and their involvement in their Jewish community. And there are examples time and time again. One last thing about this. I understand that if you look only in terms of numbers across all campuses, that while some of our academics here say it's not a problem, I don't see it in my classroom, I don't see it on my campus, I don't hear about it, and that 118 anti-Semitic acts relative to the number of students on college campuses may not seem that great,
why shouldn't we be concerned about every one of those individuals and their ability to sustain and fight back and have a Department of Education that's willing to investigate those kinds of attacks? This one is really hard sometimes for me to understand. We know what's happening on college campuses, and yes, I'm concerned about professors being able to teach. I am. But I also know that college students like my own and their friends who are on campuses who actually see what's happening, who will avoid parts of campus, I have heard from their friends, will avoid parts of campus because they're afraid if they're wearing a Jewish star that they're going to be shouted down. That's not students finding their voice. That's one student using his or her voice to stifle the free speech of that other student. Yes, Rabbi Cooper.
Congressman Deitch, I just want to come back again to this visual because it's in real time. This was posted by a professor at Rutgers University on his Facebook page. We have a young girl, 19 years old, who went to Rutgers because she wants to get her degree in food science. This is the guy she's going to have to go and sign up for because right now there is absolutely no price to pay. There's no red line, nothing about someone in a position of responsibility who openly expresses such vile hate, and there's nothing to protect that freshman from pursuing her course.
Right. And Mr. Greenblatt, am I so off base here? Have we been going down the wrong path, worrying about the 118 cases so far of anti-Semitism so far this year?
Congressman, you're dead on. I mean, again, I know some people teach courses over the course of 15 weeks. The ADL's been tracking this for over 100 years, and data doesn't lie. And what you pointed out about the definition is exactly correct. This doesn't inhibit the ability of an individual, student, faculty, or otherwise, to criticize an Israeli policy, but it does acknowledge, as that definition does, that definition, by the way, that was done in consultation with leading experts from academia and communal organizations, and it's used by our embassies around the world to track anti-Semitic incidences. So some might not like it in its abstraction, but in its practicality, I would submit to this committee, it has been vital to our State Department doing its work to protect Jewish communities around the world.
Mr. Chairman, I appreciate it. Before I yield back, I would just finally make one last point. Again, criticism of Israel, Israel's government, Israel's policies are more than fair. They're welcome here just as they are in Israel. But when you take the position, it's one thing to criticize those policies, but when you take as your position the very suggestion that Israel as a nation does not have a right to exist, and you then try to impose that to shut down others, that is not a student finding his or her voice. That is students or others on a college campus using their voices to silence others in a way that is wholly unacceptable, which this definition is simply trying to address. And I yield back. Thank you.
And I thank the gentleman, and I now recognize myself for 5 minutes. It was my turn, just for the record. This has obviously been a very compelling hearing here today for me. As it happens, a very good friend of mine is in the audience, Dr. Gary Bauer, who is the head of the Christians United for Israel, which I've been involved in that for a long time, and I think that he is perhaps the greatest friend of Israel in the Western world. So, I mean, the opinion is pretty high there. And certainly I identify with so many of the comments here today. Some of us are deeply committed to the state of Israel and to the Jewish people. And consequently, when we're dealing with the area of anti-Semitism, which it's obvious to any observer has grown in a profound way in recent days, I would suggest to you that whether it's from the hard right or the militant left, there are things that have come forward in recent days that are very disturbing and cry out for a response. And Rabbi Cooper's comments related to the necessity that there's someone just needs help here. And I understand that. I embrace that completely. The great challenge for those of us that deeply care about Israel, of course, is the more deeply we care, the more desperate we are to get the policy right. And I'm want to try to refer to the old medical term, primum non nocere, first do no harm. And so the challenge before policymakers right now is to come up with the right policy. And so with that, my first question would be to Ms. Nossel. Ms. Nossel, traditionally, our federal civil rights laws have not codified definitions or illustrative lists of discriminatory motivations. That is, our federal civil rights laws prohibit discrimination based on race or sex, or for example, without specifying exactly what a discriminatory motivation would be considered to be. Now, leaving that question to the courts and a case-by-case determination of the unique factual situations in context by judges and juries. So you see, we've struggled with this for some time. If any particular definition of anti-Semitic motivation were codified in the U.S. Code, what kinds of definitions might be proposed for consideration as constituting a potential civil rights violation in relation to other protected classes? I hope the question came across clearly.
What definitions might other protected classes invoke?
Let me say that. Let me say it one more time. If a particular definition of anti-Semitic motivation were codified in the U.S. Code, what kinds of definitions might be proposed for consideration as constituting a potential civil rights violation in relation to other protected classes?
Well, it's a good question. I think it's hard to say, but I certainly think this will give rise to efforts by other groups to think about defining discrimination against them as broadly as possible so that manifestations of that discrimination are not ignored. I mean, one example that comes to my mind that I've worked on extensively in my career is with respect to Muslims around the world and an effort that they made to try to secure an international legal ban on the so-called defamation of religion, which really related to cartoons depicting the Islamic prophet Muhammad, which they regard as a very particular and hurtful offense. And so when those cartoons were published, they went to the UN and sought an international treaty banning the so-called defamation of religion, which they view as kind of an a priori form of very virulent anti-Muslim sentiment. And they were concerned that the rest of the world didn't see it that way. So I think that's one obvious area. It's offensive. It's not universally recognized to be as offensive as some Muslims regard it to be. There are other Muslims who don't regard it as offensive and take grave exception to that effort. But I think that's one manifestation. And Ken has brought up others. What about if it was Palestinian Americans and they were calling into question the validity of a Palestinian state? Would they want to seek to define that as a form of discrimination against them, or arguments against affirmative action that, could be construed as calling into question the validity of the presence of certain students on a campus? Might that be defined as a form of discrimination? So I think it's hard to know, where it would end, but opening it up, I think, does give rise to serious concerns.
Well, thank you. Sometimes one of our challenges here is when there is a complete lack of common decency. Sometimes when it comes in these situations, it's hard to know how to respond to that best legislatively. So, Mr. Stern, I'll direct my final question to you, sir. I understand, according to your testimony, that you wrote the guidelines for the State Department, essentially that you were the lead writer on it.
I worked very closely with my colleague Andy Baker, who did the politicking and negotiating. I was the lead drafter. I was the one who probably wrote 75 to 80% of it, and got the other experts and negotiated, which parts to put in a comment.
Given that, do you think that that guideline should be something we should consider to codify in statute? I'm asking a pretty hard question here, but do you think that something like that would be appropriate in statute? Given the discussion today?
For a campus, absolutely not. That was not the purpose that it was designed for. And, I encourage the State Department to use it in its reports and bilateral relations. I worked with Rabbi Baker on a hate crime training program in Europe. Those things were fine. A campus is a different venue. It's about ideas. It's about giving students and faculty the opportunity to think outside the box, to be wrong, and not to measure what they're saying against some definition that's constitutionally enshrined. So particularly for this venue, I think it would be an atrocity.
Well, thank you
Can I
all.
comment, Congressman?
I'm sorry, I'm going to have to go to the next guy here, but I want to thank you all, and God bless Israel. And Mr. Cicilline, I recognize you, sir, for 5 minutes.
Thank you to all of the witnesses for this really thoughtful discussion. I think it's very important to say at the outset that it is my view, at least, that this spike in anti-Semitism is something which should be of grave concern to all of us, and we should determine the best and most effective way to respond to it, to eliminate it in this country and around the world. I think it is important to consider the context of this, and that is that we have an administration that I think in many ways has stoked this environment by refusing to speak out against anti-Semitism, white supremacy, and xenophobia. President Trump unapologetically came to the defense of white nationalist protesters in Charlottesville who chanted anti-Semitic slogans. Former White House advisor Steve Bannon has made a career out of promoting racist, anti-Muslim, and anti-immigrant ideas. Another former Trump advisor, Sebastian Gorka, was found to have ties to a Nazi group. And this administration has also disappointingly failed to appoint an envoy for the Office to Monitor and Combat Anti-Semitism, through which the U.S. encourages foreign governments to protect vulnerable Jewish communities around the world. So I think we would be ignoring this sort of elephant in the room to not understand the context of this spike and the gravity of it. I also find it kind of ironic in a lot of ways where in our tradition, it is by the way of free and unhindered exchange of ideas that humanity seeks the truth, and you only need to go to the Talmud to see the exchange of ideas on every page by the rabbis. So this idea of respecting and honoring the free exchange of ideas is an important Jewish value and obviously an important American value. So I guess my kind of simple question is, I think Rabbi Cooper said, you know, you don't belong here, when there's something that says, you know, you don't belong here because you're a Jew, that seems sort of an obvious anti-Semitic declaration. I think everyone would agree that criticism of Israel and policies of Israel and disagreement is not anti-Semitic as a principle. And so if we could have a definition which attempted to at least identify anti-Semitic activity in the way that Rabbi Cooper described it, but protected legitimate policy criticism, is that something we could do successfully? Or I recognize that it would open the same kind of discussion with other categories. Assuming we were prepared to accept that risk, I also reject the notion that, well, just with all due respect to Mr. Greenblatt, who I respect, knows that the fact that we just consult it, it's not binding. It matters. We ought to get the definition right if we're going to direct people to consult it. So my question for the panel really is, am I oversimplifying this? Could we craft a definition that strictly attempts to identify anti-Semitism free from criticism or disagreement on policy of the state of Israel, or is that impossible to achieve? Dr. Trachtenberg, I'll start with you.
I think it's an impossible task. I think if we asked all 9 of us for our definition of anti-Semitism, we would have 9 variants on a theme, certainly. I think we would all agree that at the core of anti-Semitism is hating Jews simply for being Jewish. If you go much beyond that, you're going to start entering into contested territory. Contested territory within the Jewish community itself, among scholars of anti-Semitism, you're going to enter into that territory. So if you want to have the most narrow definition, I think that's a baseline from which we all agree. Once you go beyond that, we're going to enter into very contested waters. And the fact that it's contested means that we should allow people who study this issue to have the opportunity to have all the debates and all the conversations that they need in order to keep fleshing this out, as we do with the page of Talmud, to keep turning it over and turning it over again to discover all of the truths and everything that we can identify within it. Thank you.
I would submit, Mr. Congressman, that it is not impossible, that my professionals do it every single day. And to clarify, the ADL was also involved in writing that definition that the State Department uses, and we think it works. But ultimately, who are the arbiters of this? Let me introduce you to the families whose children have been bullied and have thrown pennies at them. Let me introduce you to the parents whose children have had their lockers defaced with swastikas. Let me introduce you to the families themselves who have been harassed because of their religious garb or coming out of a synagogue. Let me introduce you to those people, and you can ask them whether indeed there are 9 different definitions or there's one. So if you look at the definition,
that our public servants use every day. Mr. Congressman, it doesn't say criticizing Israel is anti-Semitism. That is not what it says, period.
Mrs. Chairman?
Yeah, I was going to say that the examples that Mr. Greenblatt gives are okay, but you don't need a definition to get there. What you need in these situations is a clear understanding that Jews are selected to be victims of harassment because they're Jewish. And it doesn't matter whether that person is thinking this definition or that definition or is philo-Semitic or just, wants to do it just because they think it's fun. If a Jewish person in a campus is being harassed because they are being selected to be, because they are Jewish, that is sufficient, and you don't need to open up this whole other can
So
of worms.
could that be the definition?
Well, in the case that I brought in the Vestal district, nobody talked about a definition. Nobody talked about, do you have to show that a swastika is anti-Semitic? It's clear that these kids were picked upon simply because they were Jewish. And I would add that, we talk about the pro-Zionist, pro-Israel students. I've also seen examples that break my heart on campus, too, where a kid who's trying to figure out what they think about Israel and all this, and should it exist, and what's happening with the Palestinians, are being called traitors or kapos, and some who are wearing yarmulkes saying, take that thing off. That offends me just as much.
Thank you. Thank you, Mr. Chairman, for the indulgence. I yield back.
I thank the gentleman. I am left wondering how being the first president to stand in front of the Western Wall and pray projects some anti-Semitic sentiment.
Would you like me to answer that, Mr. Chairman?
Now call upon the gentleman from Texas, Mr. Gomer, for 5 minutes.
Well, I can help you out. Anytime a conservative Jewish person cares to speak on a college campus, they stand a much greater chance of being banned or being labeled as a hater by the haters. And it just amazes me that, well, my friend Carolyn Glick, she believes what the Bible indicates was the promised land to the children of Israel. And because of that, she canceled at University of Texas, right in my own state. It wasn't because she was Jewish, it was because she was a conservative Jewish person. And say George Soros were to come and do as he often does and beat up on Israel or Netanyahu, he would never be banned from a college campus. He'd be welcomed with open arms. So let's be real here. We're talking about particularly conservative Jewish people. Now, when it comes to school children, when it comes to people that get swastikas put on their lockers and things like that, or vile things said about them, that seems to be just because they're Jewish. And I got to tell you, I majored in history in college. I never dreamed we would get back to the level of anti-Semitism that we're seeing in Europe today, in Germany today. And I brought up to some German ministers back in August when some of us were visiting over there, how ironic it seemed to me to be that you had Germany that wanted to show, and I'm speaking to ministers of the country, so I'm being respectful, but how Germany, since World War II, since the Holocaust, has gone out of their way to try to show how open and loving they are to all peoples. So they bend over backwards to bring in what they think are Muslim refugees, some of which are not. They're there to, bring down Europe, as the Battle of Vienna prevented previously. But, I said, so you're bringing in people who are raised to hate Israelis, to hate Jewish people, and by virtue of your act to show how loving and open you are, you're bringing in people that make you appear to be anti-Semitic again. And of course, that raised some hackles and got some people upset, but it's certainly the way it appears. There are college campuses that are going out of their way to try to appear so embracive of Islam that they become anti-Semitic. And when my friend condemns my friends, and I mean true friends, Bannon and Gorka, they were called, these guys are not anti-Semitic, and they are not anti-Muslim. but they certainly recognize that there is a portion of Muslims who believe the United States and the Western civilization must be brought down. And there's nothing wrong with saying that and believing that, and nobody should have rules pulled out to prevent them from speaking for saying that. I mean, for heaven's sake, Brandeis University withdraws their offer of a doctorate to Ayaan Hirsi Ali. I mean, she's an atheist as I understand it, but what a courageous person. I mean, what happened to Brandeis? I mean, have they forgotten why they were founded? I know Harvard and Yale forgot how they were founded. They don't want conservative Christians or conservative Jews coming in and speaking, but they'll welcome anybody that'll come in and bash Israel. So I welcome all the comments I've been hearing from people across the aisle condemning anti-Semitism, but I would hope my friends will be just as upset when it's a conservative Jew. And as far as the boycott that seems to be growing across the world, and particularly in Europe, of anything made in Israel, it's just another effort to slam Israel. But I have stood there at the tomb of King David's father, Jesse, in Hebron. Hebron also is where Abraham and Sarah and Isaac and Jacob, their wives, are buried right there. And I'm supposed to say that that is absolutely not Israeli territory and we should ban anything coming from that area? That is ridiculous, and we need to be more realistic in our assessment of what truly is anti-Semitism. It applies when it's a conservative Jew. Thank you. I yield back. I see my time's up.
I thank the gentleman, and I now recognize Mr. Raskin for 5 minutes.
Mr. Chairman, thank you very much. The very first thing that I did as a newly elected member of the House of Representatives was to organize a tour of the freshman class, the Democrats and the Republicans both, to the Holocaust Museum, and we spent 2 hours there, and I believe very strongly that the touchstone of our politics has got to be in opposition to anti-Semitism and racism and the other hatreds that made the last century such a nightmare for so many people. I'm also a professor of constitutional law, so I'm very sensitive to the free speech concerns that have been raised by many of the witnesses today. But I want to try to look for some common ground coming out of the panel, and I want to start with this. Title VI prohibits discrimination based on race, color, and national origin, but not on religion. Does everyone on the panel agree that religion generally should be covered under Title VI? And forgive me, I have so few minutes and there's so many of you, but if you don't mind going down the aisle, does everybody agree that religion should be covered? Yes, no, or no comment will suffice. Starting with Rabbi Baker, if you would.
Well, my focus is Europe and not here, but I think that you open an entirely new avenue of debate when you say it should cover religion.
Yeah, okay. I was hoping for a yes or no just because I have so little time. So,
Yes.
Yeah, okay.
Yeah, I'm not sure it would address the issues we're here today. I think it would expand properly so, but it would be a whole nother discussion to come back at another time.
Okay.
I actually agree with Rabbi Cooper here that this is actually opens up a larger set of issues that we need to address.
Okay.
It's not simple yes or no.
Okay.
And I would agree it's complicated. You have other things like the Free Exercise Clause and Religious Freedom Restoration Act. I mean, there's a lot of things that make it complicated.
Okay.
Likewise, it's outside the scope of our organization and its mission.
It's complicated? I think it's complicated as well, but religion should certainly be protected.
Okay.
I think religion should be protected, but in ways that are careful to be compliant with other constitutional and legal provisions.
And I would agree with that. It's particularly about harassment on the
Okay.
basis of religion.
It seems like there's a category of speech that has been heavily contested here, which is that relating to the Israeli government or the Israeli state in terms of its anti-Semitic content. But would everybody agree that, for example, what took place in Charlottesville is anti-Semitic? But does anybody believe that, for example, Richard Spencer, who now seems to be on a nationwide speaking tour, does everybody agree that he does have a First Amendment right to appear at least on public campuses? Does anybody think that he does not enjoy a First Amendment right to speak on public university campuses. So everybody seems to agree that he does. Okay. Well,
Mr. Congressman, unless he incites violence against people.
unless he incites violence, yeah. But in terms of the content of his speech, that he should not be banned for that reason. Okay. So I want to go to the question that has tormented the country for a while now about statues of Confederate soldiers, Robert E. Lee and Jefferson Davis and so on. I've got no doubt that the vast majority, or I would dare say all racists, support continuing keeping those there. But a lot of people who support keeping those statues up are not racist, right? So would it not be a problem to use as indicia of racism whether or not someone supports having those statues present there? And perhaps
I would
Stern,
agree with that. I mean, my view is not germane to this exactly, but if you remove all the statues, people don't see the history. I'd rather put them in context and let them be used as a way to explain why they were put up in the first place for support segregation and so forth.
But just
that wouldn't be a hateful view.
Okay. All right, now let me come to this now. So my dear colleague, Mr. Deutsch, read the operative definition that he had. I might even broaden it a little bit just to say that anti-Semitism is discrimination, prejudice, or hostility against Jews. It seems like what's getting everybody into this searing controversy is the illustrations or the examples that were offered in the State Department policy. But does anybody know of an anti-discrimination statute that's been passed by Congress that includes illustrations or examples? Because to my knowledge, there's not one. And so does anybody think that those illustrations or examples are necessary to the definition? Okay. Can you explain, if you would, Rabbi?
The whole idea of the examples was to show how it plays out in a practical way so people who have a responsibility to address the problem will understand it.
Right. Let me just cut you off there for a second because I have so few seconds left. But when we wrote the Title VII statute, when we talk about race discrimination or sex discrimination in the workplace, we leave it broad and we let the courts work it out, whether or not there's a discriminatory animus or motive. So well, I'm just thinking in terms of trying to keep civilization together here and to keep our unity together, why would we get into a series of controverted examples that are going to divide people as opposed to stating what the principles are and then allowing those to be worked out in practice? I don't know, Mr. Trachtenberg. Let me just come to Dr. Trachtenberg, and I'm happy to come back to you.
It's the examples in particular.
Because in 2004, in the Global Anti-Semitism Review Act, Congress said that anti-Semitism has at times, I quote, taken the form of vilification of Zionism.
Okay, so, but I'm talking about a discrimination statute. Dr. Trachtenberg.
Gentleman's time has expired, but Dr. Trachtenberg, you can answer.
I am, thank you. The examples in particular are, well, the examples are particularly problematic, but against the idea of having a definition which is going to box us in terms of what anti-Semitism is really at the root of our discussion here.
Thank you very much. I yield back, Mr. Chairman. Thank you.
I thank the gentleman. And now the gentleman from Texas, Mr. Ratcliffe, is recognized for 5 minutes.
Thank you, Chairman. Appreciate all the witnesses being here today. Our nation's college campuses are supposed to be a marketplace of ideas where students from all kinds of different backgrounds can learn new perspectives based on everything I've heard. It seemed like a lot of our college campuses have become bastions of self-proclaimed political correctness, and that in turn has led to the outright harassment of some students based on their beliefs. And I think that's readily apparent in the treatment of Jewish students across the country. I referred to the report, I think it was in, Mr. Clement, I think it was in your testimony about just this year, 1,299 anti-Semitic incidents from January to September. I think, again, it's troubling that political correctness seems to have allowed anti-Semitism to flourish. But again, I appreciate the thoughtful discussion here from all the witnesses, and as we try and get back to this having our institutions of higher education be that marketplace for ideas while also stemming the rising tide of anti-Semitism. I appreciate all of your perspectives today. Mr. Clement, let me, I know one of the things that you focused on in this Anti-Semitism Awareness Act, and you know, I read your anticipated responses to the First Amendment concerns and regulations of speech. Is an oversimplification to say that having a definition as proposed within the Act is trying to find that line between speech that is anti-Zionist versus speech that is anti-Semitic?
I think that's what the definition is trying to get at, Representative Ratcliffe. I think it is, you know, there's a particular concern in the context of anti-Semitism that I'm not sure is present in some of the other discrimination prohibited by Title VI, which is you do have this ability for people to essentially cloak it and say, oh, it's not anti-Semitic, it's just anti-Zionist. And so I think the definition is trying to get at that. You know, the other thing, and I know a couple of questions have sort of, you know, kind of gotten to the question of, do we really need a definition here? And what I would say to that is, you know, in the abstract, it might be fine to have anti-Semitism defined on a case-by-case basis over time, but to have a case-by-case definition, you need cases. And one of the things I think everybody is seeing here is that it's not that there aren't anti-Semitic incidents on campuses, and yet there are no enforcement actions. And so I don't think we have sort of the luxury of just letting, you know, the education department sort of develop the definition over, you know, the course of a number of enforcement actions. I think, in a sense, we need to jumpstart the process. And I think the definition is designed in part to do that, and then in part to guide the discretion of the education department officials.
Well, I think I agree with you. I think there needs to be a specific point where we can point and have a determination of where criticisms of Israel cross over into anti-Semitism. And I go back to that report that's referenced in your testimony about the 1,299 incidents, and I also go to Rabbi Cooper's written testimony that the Department of Education's Office of Civil Rights has never found a civil rights violation in any claim filed on behalf of Jewish students. So put on your Solicitor General hat, if you were making this argument, is that to a court is the fact that you have all these reported incidents, yet no violations found, would seem like that is a violation of equal protection under the law for Jewish students based on that type of evidence.
I think it would sure be a difficult thing for any Solicitor General to try to explain. And I think it's the kind of thing that would give rise to an inference that something other than just looking for the exact right case and prosecutorial discretion is going on.
Rabbi, I want to let
Yes,
you weigh in on that as well.
Congressman, let me just make 2 points very quickly. This definition, you know, had an evolution starting with the OSCE, 56 out of 57 countries, of course, minus Russia, eventually agreeing on, and the evolution down to our discussion this morning. It's probably the best definition that we're going to get, and it's the most relevant one. To really summarize, and I'm pleased that both Mr. Franks, the chairman's here, you have the wall-to-wall leadership of the American Jewish community here. We came, I would say, hat in hand. We have a problem, we need your help. And I think what we would respectfully ask for is, after the appropriate deliberations, that with all of Congressman Raskin, former professor, all of these important questions that have been raised, we need to move the ball forward. We hope you'll send this to the floor of the House for further deliberation. I have no doubt that if it's passed, there'll be many challenges just by virtue of the testimony you heard today. But you have the entire Jewish leadership of the American Jewish community coming together united, something that apparently nothing less than this great committee has been able to achieve. And we really hope that after the appropriate deliberation, it'll be moved forward for a vote on the floor.
My time's expired, Rabbi, but I will tell you that I agree with that sentiment, and if I was sitting on the top row, I might have a little more influence in making that happen, but appreciate you all being here today.
Chair, thanks, gentlemen, and recognize the gentleman from Illinois, Mr. Schneider, for 5 minutes.
Thank you, Mr. Chairman. Thank you for calling this important hearing. I want to thank all of the witnesses today for sharing your perspectives. I do want to take a prerogative and welcome in the gallery Lisa Sugar, who represents the Jewish Federation of Chicago, where I represent. As I've listened to the testimony today, the questions, I can't help but listen as a Jew. As the parent of Jewish college students, one current and one recently graduated, I represent a state in which at least 6 of our universities have recently experienced anti-Semitic incidents. I am personally gravely concerned about the recent significant rise in anti-Semitism on our campuses and our communities, in fact, around the world. As Mr. Greenblatt, you said, we must count each and every one of these incidents and leave none of them to go unanswered. What we're seeing in campus, I fear, is an increasingly organized, concerted, and well-funded effort to create a hostile environment for Jewish students to publicly express their Judaism as well as their support for the Jewish state. It doesn't take a lot of events or a lot of incidents to make it difficult for Jews to feel comfortable in the academic environment where they are, as I think we've all agreed, seeking the opportunity, as every student should have, to explore new ideas, to find their voice, and to reach their own conclusions. That's what the university is for. But I do worry about this difference. So maybe I'll start with you, Mr. Greenblatt. Do you see a difference between free speech and a concerted effort to create a hostile environment?
First of all, Mr. Congressman, thank you for the question. As a former resident of North Shore of the Chicagoland area, it's nice to see you here today. I think it is safe to say that there are challenges, again, as I had stated in my oral testimony, from both what the Congressman Franks called the hard right and sort of elements of the militant left. We have it on neither side of the ideological spectrum is exempt from intolerance. But whether they are organized campaigns or they are spontaneous actions, we need to be clear about the fact that, again, Title VI doesn't explicitly protect these Jewish students. And considering the number of cases we are dealing with on campus today, the stat that the Congressman Deutsch represented was correct. The number of investigations led by the Office of Civil Rights, Department of Education, case of anti-Semitism, 0. Let me repeat, that number is 0. We believe having a definition will make it easier for whoever's administering the office, whether it's indeed Mr. Marcus or someone else, to ably do their job and ensure that Jewish students have the same protection that other students have. It doesn't preclude political speech. It doesn't limit freedom of expression. It simply ensures a definition that we also worked on is utilized by policymakers and campus administrators.
Mr. Stern?
I just want to share a short anecdote. I was doing a training for students at Columbia a number of years ago on anti-Semitism. We started at 7, we were still talking at 11, and they said this is the first time they felt open speaking about Israel. I said, oh, that's interesting. You know, is this the only issue that you have trouble speaking about openly? No. Your friends in other campuses have a problem too? Yes. Everybody's sort of worried about whether they're going to step into a landmine in the context today. And what I worry about this legislation is it feeds into that rather than breaks it down. I think the answers are not with legislation that's going to create an additional sense of, you know, these are folks here and those are folks there, but initiatives that campuses are lacking on to how do we have these difficult discussions. There are very few classes on anti-Semitism. I think if you have more classes on anti-Semitism, students are going to understand the issues that combine us and divide us here today much more deeply and will affect the campus environment. Those are the things that need to be done, not this type of legislation.
Well, I appreciate that, and I agree that we need more classes on anti-Semitism. I think that would be a beneficial step forward. But that doesn't change the fact that there are efforts on these campuses to make these Jewish students feel profoundly uncomfortable, unwelcome. I think it was you said, putting out a sign, whoever you are, saying you are not welcome here. I've been to campuses where the signs say, hate is not welcome here. I think that's a much better sign.
That's right. And the question is, how do you help administrators? I think Mr. Greenblatt has said that too in his testimony. How do you help them think through cultivating that environment in which you have the capacity for students to be wrong, to say what they think, but then others to identify what's hateful, and then to teach about it? There should be no question that Israel and Palestine, as contentious as that is, should be an ideal subject for getting students to think about how do you deal with the competing narratives and competing histories, how do you look at identity, how do you look at the equities and so forth, rather than just feed them into if something's said about Israel that's anti-Zionist, that's anti-Semitism, that ends the matter. It should be the beginning of the questions, not the end of it.
All right, Rabbi Cooper, my time's expired, but
Just very quickly, classes alone and dialogue, as welcome as they are, will not protect your kids on campus. And when there is an incident, and we've now heard over the last few hours, there are many, we need the help of our government to ensure that Jewish students are afforded the same protections as everyone else on campus.
Would the gentleman yield for a second?
I will yield.
Thank you. I just want to make clear for the record that a mistaken statement was made a moment ago. Not every Jewish group supports this bill. I have a letter here, for instance, from J Street U opposing it, and there are groups that do not support the bill and the groups there are. So I just wanted to clear that up for the record. Thank you.
Well, my time has expired. I wish I had more, but I will yield back.
Chair, thanks, gentlemen. Recognize the gentleman from Colorado, Mr. Buck, for 5 minutes.
Thank you, Mr. Chairman. Dr. Trachtenberg, quick question. In 2013, did you sign a petition to boycott a conference at the Hebrew University in Jerusalem? And did the petition state that the Hebrew University is deeply complicit in the occupation, settler colonialism, and apartheid?
Yes.
I can't hear you.
Yes, I did.
Okay. And did you also vote for the Modern Language Association to boycott Israel?
I'm not a member of the Modern Language Association.
But did you vote for a boycott of Israel with that group?
I wouldn't have had the capacity to vote for it because I'm not a member of the MLA.
So that's a no?
No.
Okay. And Mr. Clement, I wanted to ask you a question, and I guess I want to respectfully point out something that my colleague, Mr. Raskin, said. He said that all racists are in favor of keeping the Civil War monuments, to paraphrase. And that indicates something to me that's deeply troubling, that what he's really saying is that all racists have to be white in this country. There's no such thing as a black racist that might want to take down those monuments. And I think when we look at this issue, we look at it through our own lens, through our own bias. And that's what I think we're really struggling with here, is how do we respect the Constitution, at the same time deal with a deeply troubling issue on college campuses, and that is the issue of anti-Semitism and bigotry and hatred. And my understanding is that there is a Supreme Court case in 1999 that gave us a definition, the Davis case. And just want to quote that and then ask you a question. It found that peer-on-peer harassment in the educational context is so severe, pervasive, and objectively offensive that so undermines and detracts from the victim's educational experience that the victim students are effectively denied equal access to an institution's resources and opportunities. If that is the Supreme Court definition, why don't we use that definition in this bill and instruct the Department of Education to proceed in that way?
Well, so Representative Buck, I think that's, it's a very fair question, and I think that what I would say is that right now, I assume that in administering, it's slightly different context, it's Title VI versus Title IX and the like, but I would assume that that is in fact the standard that the Education Department is using right now in administering Title VI with respect.
It sounds like it isn't using any standard, because it hasn't done any work on this in this area, and it's a desperately needed area.
Well, but I think there's two issues to keep separate, and one is, what is the level of conduct that rises to the level of harassment? And then the second question is, if there is harassment, then Title VI still doesn't prohibit it if it's not on the basis of race, national origin, and the like. And so what we're really struggling with in this particular context is to try to get a definition of anti-Semitism that will work for the motive part of the inquiry. I don't think this bill is designed to really move the needle on what level of harassment is necessary to sort of bring a Title VI action. And I think, though, as I've tried to suggest, that that question probably has much more to do with the First Amendment than the question of how we define anti-Semitism. And I would say from a First Amendment perspective, we are much better off having government officials with a definition than without a definition. And just to refer to, just for a second, the statistics we've heard a lot about. So there are 0 cases currently being brought. Now, in the event that the reason 0 cases have been brought is because not one of the cases that they investigated rose to the level of harassment under the Davis case, then that would be an acceptable result from a First Amendment standpoint. That would be the reason these cases aren't being brought is they don't rise to the level of harassment. Now, I strongly doubt that's what's going on, and if the question is if some subset of these hundreds of cases rose to the level of harassment and they weren't being brought because of some confusion about what constitutes anti-Semitism, that is the problem that
and I'm going to interrupt you just for a second because I want to get Mr. Greenblatt's view on that. Which is it? He just gave you 2 options.
Well, I can't say with definitively because I'm not familiar with every
Sure you
case.
can.
Well, I don't know all the cases they're looking at, but I can say indeed it is. It would be reasonable to look at those cases and determine whether or not the lack of a definition prevented the office from doing their job effectively with respect to these specific instances where Jewish students are affected.
Thank you. My time is up, and I yield back.
The chair recognizes the gentleman from Georgia, Mr. Collins, for 5 minutes.
Thank you, Mr. Chairman. I think this has been an interesting discussion, listening to, putting 9 people on a panel and all going at it. Wow, this is like throwing the ball and having a scrum and seeing who wins at the end of the day. But it has been good to discuss this because this is one of the things, anti-Semitism and other forms of discrimination are abhorrent everywhere. It doesn't matter where they're located, and this is an issue that is particularly troubling when bigoted acts of harassment prevent students from basically accessing education. But I want to focus back, as I think I look like I'm probably the last one here, going back to one of the arguments that I've heard about this against this in many ways is the First Amendment issue. This is a First Amendment issue. So I wanted for Ms. Clements, you've been in front of the Supreme Court more than any of us here. And also, by the way, my legislative director, Sally Rose Larson, who took constitutional law for undergrads, is glad. She says hello, but she's also glad she's not here. She didn't want to be tested on this. So we appreciate that. But Ms. Clement, you've argued these cases, and I think you might be unique to discuss this. I want to discuss it from this level. Title IV of the Civil Rights Act prohibits discriminatory conduct, not speech, correct?
Title VI, that's right. That's what it's directed at, the harassment, as we were discussing.
Okay. What role does the evidence of discriminatory speech play in analyzing allegations of a violation of the Civil Rights Act?
And that's where the Wisconsin against Mitchell case makes quite clear that evidence of, including speech, can be used for an evidentiary purpose. And so even though I think, in Wisconsin against Mitchell, you had 9 Supreme Court justices that are very protective of the First Amendment, they unanimously held that you can use speech in that kind of evidentiary way.
Okay, to show the intent that we're talking about here.
Right, exactly.
Okay. So let's continue on this process. In consideration of potential violations of Title VI stemming from discriminatory motivated harassment, how does one distinguish between the protected speech and the non-protected conduct?
I think that's where it's really the harassment test that has to do the work, because this, the Supreme Court has basically said that we can, that there's a different level of protection for conduct as opposed to speech, and when you have conduct that rises to the level of harassment, I think it's common ground that it's perfectly permissible to say that we are going to prohibit the harassment if it's motivated by race, national origin, or anti-Semitism, and then it's just a matter of trying to figure out whether that's in fact what motivated the harasser. And in that inquiry, then you can take into account speech, doesn't raise a First Amendment problem by virtue of a unanimous Supreme Court, and it just seems that in figuring out whether the speech, the conduct, sometimes it could be a combination of both. I mean, if somebody spray paints a swastika in somebody's dorm room, That's probably more conduct than speech, but all of that can then be used in order to make a determination whether the harassing conduct was anti-Semitic and therefore violates Title VI.
But many times in looking at this, you're not, there's a concern in many circles are you, in crossing over this area, especially in hate crimes or other things, are you criminalizing the thought? Are you criminalizing that thought? I'm not sure if a definition in the sense that we're talking about here with this act actually goes that far. In what you're saying, would this definition impinge on this free First Amendment rights or some of the list of horribles that have came from several on the panel today?
I don't think it would, and I think maybe one way to think about the difference is this would be a very different situation if this was a proposal to say that the following anti-Semitic speech will be prohibited, and here's the definition. But that's not what this law does. It takes an existing framework that only reaches conduct that rises to the level of harassment based on a certain level of motivation, and then uses this as a way of figuring out what motivation counts.
And what Ryan doesn't seem to be working at all, since we're not seeing this being brought forward. Although we're seeing it out in the world, very evidently, we're not seeing it brought in these cases.
That's exactly right, and that's why, look, in the abstract, one could say that maybe we don't want a definition written into the statute, and we'd prefer to do it case by case and have courts develop it, but you need cases. And I think what we're seeing here is that there are no cases that are allowing us to develop a definition through the judicial process. And so it makes sense why Congress would want to step in here, even if it wouldn't necessarily feel like it needed to step in some other context.
And I appreciate the other witnesses. I do have one last question because it was brought up earlier concerning your testimony concerning this and what was put into this. It says shifting to this legislation, the Anti-Semitism Awareness Act, includes a savings clause. And hypothetically, without the savings clause, in your opinion, would this violate the First Amendment, and if so, why?
I think this would be perfectly constitutional without the savings clause for the two principal reasons that I've given. One is that it essentially is not a direct regulation of speech, but only essentially an evidentiary test for the motivation for harassment. And second, because the definition actually serves First Amendment values. I just think the savings clause, I mean, to the extent that somebody, with any statute, somebody can come in and say, well, maybe it's going to, even though it's not unconstitutional on its face, maybe it'll be applied in the wrong way. And I think the savings clause gives some additional sort of comfort that that's not the way that this statute would be applied.
Well, I think the panel today and all 9 opinions have served well to know that you can apply it pretty much any way from any angle that you want it. But I think it's been a good discussion. I think this is something that we do. I agree with my friend from Texas just a few minutes ago. This is something we need to, I think, can move forward on without infringing on the First Amendment rights, which was the overall issue, and bring some clarity that may be lacking in this point today. But that is the reason we move forward. It is not simply because we have questions that we should not move forward. It is the very fact that we have questions that I believe should move this forward. And with that, Mr. Chairman, I yield back.
Chair, thanks, gentlemen. I want to thank all the witnesses. This has been an excellent hearing. I think we have helped to shed a lot of light on a very important issue. I am deeply concerned about what is happening to Jewish students on college campuses, and I think that we need to work together to find the right approach to make sure that the forces are brought to bear, including the U.S. Department of Education, to solve this problem, and I'm sure this dialogue will continue. But all of you have made a great contribution today, and I think you've helped to educate the members of the committee. So this concludes today's hearing, and I again thank all of you for your participation. And without objection, all members will have 5 legislative days to submit additional written questions for the witnesses or additional materials for the record. And with that, this hearing is adjourned.